All right, we're on record today for the initial disposition as it relates to one parent and a pretrial on another two. I had a brief update from our attorneys just before I got in that there may be a request to enter a plea. So I'll look forward to that as well as any other comments after appearances, beginning with our guardian ad litem.
Good morning, Nicole Underwood, lawyer, guardian ad litem for the minor children.
Ms. Naja Thomas, counsel for the department. Present is our foster care worker, Ms. Kristen Smith, and then also for pretrial purposes, the CPS worker, Ms. Chelsea Grant. Ladies, if you would please state your name for the record.
Kristen Smith, foster care worker, Catholic Charities.
Chelsea Grant with the department.
Michael Brooks, I represent one of the fathers, Mr. Tyler Anderson.
Tyler Anderson.
Michael McFarland, representing the other father. Please introduce yourself.
Zach Davis.
Catherine Jim Rock for Father Brianna Davis. Brianna Davis.
Could you say that one again?
Brianna Davis.
Preonna?
Yep.
Okay, thank you so much. All right. Mr. Anderson's initial disposition is set for today. Let me go back to our attorneys for the other two parents, the Davis parents, updates on how you may like to proceed.
Your Honor, there are allegations of criminality, specifically domestic violence, from my client. Based upon that, entering a no contest plea. I've spoken to the guardian ad litem, who has no opposition.
Your Honor, we would be doing a contest as well based on retracting and or criminality of lying to the police with regards to their investigation. And I don't believe the lawyer guardian ad litem has any objection to that either.
Your position, Ms. Thomas.
I think that's appropriate, Your Honor.
Any objections, Mr. Brooks?
No.
Ms. Underwood, if you could confirm your position on that.
I have no objection to the no contest, please.
All right, and do you believe that the court accepting the plea of these two parents on that context serves the best interest of the children?
Yes, I do, Your Honor, as it will allow the parties to begin working the case service plan and hopefully working toward reunification.
Thank you. Very good. All right, Mr. Brooks, do you have a preference on whether or not we take the initial disposition of your client first?
No.
All right, well then, let's go ahead with the plea. Deputy Ames, could you swear in Zachary Davis and Brianna Davis, please? All right. A no contest plea means that I'm essentially going to consider the contents of the petition as being accurate for purposes of deciding the best way forward for trying to order case services and order your services. But it also means that it would be something that I could consider later on in the case as well. So I'm going to go over some of your rights with you as it relates to this, but I just wanted to kind of give you a little context about the no contest plea first. If I accept your no contest plea, you are both giving up the right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand? You'll be giving up or waiving the rights I've just indicated to you if you enter a no contest plea to the allegations in the petition, Mr. Davis?
Yes.
Ms. Davis?
Yes.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in proceeding to terminate your parental rights. Do you understand the consequences of the plea, Mr. Davis?
Yes.
Ms. Davis?
Yes.
Do you have any questions about any of the information I've given you so far, Mr. Davis?
No.
Ms. Davis?
No.
Thank you. Is anyone forcing you or making you or threatening you in order to get you to enter a plea, Mr. Davis? Ms. Davis?
No.
Has anyone promised you anything in order to get you to enter a no contest plea, Mr. Davis?
She has to hear it next.
No.
Ms. Davis?
No.
Are either of you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing right now, Mr. Davis?
No.
Ms. Davis?
No.
Would you say that your decision to enter a no contest plea is one you've made of your own free will, Mr. Davis?
Yes.
Ms. Davis?
Yes.
Very good. As it relates to the factual basis of the plea, would you have a witness to swear to the petition or to outline those issues, Ms. Thomas?
Oh, I would call Miss Chelsea Grant.
Ms. Grant, come on up to our witness stand.
Miss
Thomas.
Grant, thank you, Your Honor. Miss Grant, how are you familiar with this matter?
I was the assigned ongoing case manager.
And did you draft the petition that is before the court today as it relates to Mr. and Mrs. Davis?
I did.
And to the best of your knowledge, are the allegations contained therein accurate and true?
It is.
As it relates to the family, what would you describe the areas of need that they can work on through a case service plan and that the court can monitor to ensure the safe return of their children to their care and custody?
The main ongoing conflict in the relationship with the family is going to be the domestic violence that the parents engage in, that the children are witness to. Additionally, there are some concerns with alcohol usage and that ongoing usage off and on throughout the relationship that seems to cause a lot of the domestic violence situations. The children have experienced a lot of the trauma from the experience of witnessing the domestic violence and then getting them into services, including CTAX, therapy, those kind of things.
Are is parenting education also something that the parents may need to undertake for the benefit of their children?
It is.
Are there any concerns about stable housing or employment and income?
So both the parents right now have a home that my understanding is the mortgage or rent is paid up until I think for several months still. They are self-contractors. They run their own business. They do door dashing, construction. So just making sure they're stable pay going in and out.
Okay. Your Honor, I would just ask the court and fellow counsel if the factual basis with Ms. Grant attesting to the petition is sufficient at this time.
I believe so, Your Honor. We're specifically relying on paragraph number 9.
And I was relying on paragraph 8 F through I, and then paragraph 11 A and B.
Could you say that again a little louder?
Sorry, I was relying on paragraph 8 F through I and paragraph 11 A and B, and I think that that's sufficient.
Thank you. That's good.
I have no position on these folks' case.
Ms. Underwood?
I agree, that satisfies the requirements.
Thank you. All right. I would also agree. I also find the plea to be knowingly, understandably, and voluntarily made with a full understanding of the consequences. I find the record supports one or more of the statutory grounds alleged in the petition are true. There has been a violation as a result of the domestic violence dynamics and the child abuse dynamics, frankly, in the home of these two parents that has created a situation where they have neglected or refused to provide proper care, necessary support for the children's health or morals, and that these incidents have subjected the children to a substantial risk of harm to their mental well-being. I also find the home or environment as a result of those actions have caused it to become an unfit place for the children to live at this time with both parents in the home. We'll set an initial disposition. Have you had a chance to talk with these two parents at all about a case services plan?
That would be Ms. Smith.
Okay, all right. Do we need to have any more witness testimony from Ms. Grant this morning necessary then, Ms. Thomas, on this or the initial disposition?
No, Your Honor.
Any other questions for this witness?
Just one.
Go ahead.
I know my client is already engaged in services such as psychiatric medication and counseling. Would there be a family key meeting with him to kind of incorporate some of these things, which he's already doing?
That was something that Ms. Smith would be addressing in her case service.
Okay, okay. Any further?
No question, Your Honor.
Mr. Brooks, any
No,
questions?
No, none.
Ms. Underwood?
No questions, thank you.
Thank you for your testimony. You may return to your seat. All right, let's head into the initial disposition. You have a witness on that, Ms. Thomas?
Thank you, Your Honor. Yes, I would call Miss Kristen Smith.
Go ahead whenever you're ready.
Thank you. Ms. Smith, you are the assigned foster care worker for the family, is that correct?
Yes.
Okay, and for today's hearing, you've provided a copy of a proposed case service plan for Mr. Tyler Anderson, is that correct?
Yes, it is.
And in, I believe that you've also filed a signed copy at this point. Is that
Yes.
true? Okay.
Yes, I just filed it this morning when I was able to meet with him in person to get the signature.
At this time, what is the permanency goal for Mr. Anderson and his child?
Reunification.
And what were some of the areas of concern that would need to be addressed by Mr. Anderson before reunification would be possible?
Given the gap of time that Mr. Anderson has had with Liam, we would encourage and hope that over time they could, strengthen the bond. There were some housing issues that still need to be addressed. Hopefully the department is able to help with, I'm not sure about funds or things that are available, but we want to look into getting some issues resolved with the house. Still waiting on verification of employment, transportation. I know that he said that he has reliable transportation. I'm just waiting on driver's license, registration, proof of insurance. Also, he just recently obtained the housing, so we would just like to see that he's able to maintain stable housing before we would look at, moving Liam or expanding to unsupervised visits at his home.
Okay.
I think I also did list in there parenting education. I think that everybody can benefit from some part of a parenting education course. So him and I discussed that as well.
Okay. Just a reminder, we are on YouTube at this point. You've already said the child's name, but moving forward, if we can refrain from that, please. Are there any other concerns? Were there any concerns for any mental health issues or any substance abuse issues with Mr. Anderson?
Not at this time. I think that given the very short time that I've had with the case, it's hard to meet with a parent once or twice and know everything that they're gonna need. So hopefully as the case kind of progresses, I'm able to work with Mr. Anderson, and if something were to come up, we could discuss that or add it to his case service plan later. But at this time, there wasn't a concern for mental health.
Okay, thank you for that. And in creating this case service plan, you were able to consult with Mr. Anderson?
Yes, I was.
Were there any other areas that he reported that he may need support in?
No.
Okay. And currently the parenting time, well, let me ask, are there any other voluntary services that he's started or been participating in that you're aware of?
Not that I'm aware of, no.
Okay. And parenting time, has he started to exercise any parenting time?
Yes, he has.
Okay. And that's the Mondays from 4 to 5?
Correct. We started essentially kind of slow just because of the time that had went on between him and his son. I've only supervised one. The very first one was supervised at DHS by CPS. He has a scheduled one today. From what I've seen, honestly, you wouldn't know that there was a year and a half that had went on since they had really seen each other. They appear to pick up right where they left off. They had a really good time. So the agency at this point would just look to expand it in frequency, duration, move to unsupervised within the community, let him become a little more involved in extracurriculars, medical appointments, dental appointments, and so on.
Wonderful. Thank you for that. And will that just be part of a family team meeting to discuss how that transition may look?
Yes.
Is there anything else that you believe the court should know as relates to Mr. Anderson?
No, not at this time.
Okay, thank you. Your Honor, as relates to Mr. Anderson, I would ask the court to accept the proposed case service plan.
Any objections?
None.
No objections. No. Thank you. It is received, and I have tracked down the signed one. Thank you.
Ms. Smith,
Question. I'm sorry.
I'm sorry, just as a couple of other questions, as relates to Mr. and Mrs. Davis. Have you had an opportunity to meet with them to discuss a potential case service plan at this point in time?
I have met with them both to do the initial paperwork, just specific really to our agency, but we've discussed what services would look like. I do know that I've gotten releases already signed for services that Brianna was engaging in. The day that I met with Zach, I didn't have any at DHS with me, but not specifically to create or develop the case service plan. No, we haven't.
Okay. Thank you for that information. And then for parenting time for Mr. and Mrs. Davis at this point in time, what is their parenting time like for them?
Mr. Davis visits on Wednesdays, supervised at DHS from 4 to 5 with the youngest 2 children. And then Mrs. Davis visits with all 3 children on Tuesdays and Thursdays at our office from 4 to 5 currently.
And is there any concern about parenting time for either of those parents at this point in time?
It's also very new to the case. I've only supervised 1 parenting time each. So it would be difficult to say, oh, what I've supervised, they were, appropriate during the visit. We encourage them to bring the necessary items to the visit. So like I said, it's too new to speak on that.
Okay. All right. Thank you. I have no further questions, Your Honor.
Questions, Mr. McFarland?
So you'll go over with my client what's anticipated that we bring to these visits, correct?
Yes, we have.
He's getting, I understand you 1 visit per week?
Correct.
The duration is how long?
1 hour.
This court traditionally awards 3 visits at 2 hours. Is there any reason why that cannot be accomplished?
We were going off of the parenting, the recommendation that was made by the parenting assessment.
Okay. Last time we were in court, my client indicated Native American heritage and his father would have additional information. Were you able to interview his father?
I was not.
Have you done anything with the Native American heritage issue?
I believe they were sent out by the CPS worker, and then I had touched base with Miss Davis, and she had provided me with a little more information.
But nobody has touched base with my client's father, who indicates he has information on his own specific Native American heritage, correct?
No, I have not.
Okay.
If the CPS worker did.
So right now we'll be utilizing active efforts in our case service plan until we get the until we get the answers back from the tribes or the Indian Affairs, correct?
Correct.
Any further?
Questions, Ms. Dumont?
Ms. Smith, is there anything that Ms. Davis can do at this point to work towards increasing her parenting time that she currently has?
At this time, her and I, the last time we spoke, it was just by text, but I had just encouraged her to continue engaging in the services that she was engaging in, as long as the agency doesn't see concerns during her parenting time. We've talked about a family team meeting to see if the relative would be appropriate. That way she could allowing her to attend medical appointments, dental appointments, and so forth.
Thank you.
You're welcome.
Mr. Brooks, any questions?
What is the age of my client's child?
9.
Thank you. That's all.
Ms. Underwood?
Ms. Davis, at this point, do you think it would potentially be appropriate to allow visitation for Ms. Davis to occur in the relative placement?
Do I think that it would be appropriate?
Yes.
Yes and no. I'm hesitant just for the fact that we would be nervous as Mr. Davis and Mrs. Davis are still planning together. It is my understanding that they don't have intentions on separating. So we would be concerned how that is going to transpire when only mom can visit in the home, as the caregivers are not willing to allow him into their house. If we did allow the caregiver to supervise a visit, we would still just ask that it remain structured and not be just that she can come over, anytime, any day.
How are the children adjusting to being placed with their maternal grandparents?
I think that they're doing overall okay. When I spoke with them, they, are excited to live with grandma and grandpa. They were excited to show me, their vet, and they definitely do miss at least the middle child, the little girl. She does struggle and she does miss mom. That visits are difficult afterwards. But I think that overall they're doing okay. They did just all have dental appointments. All the two boys have significant, extensive dental work that needs to be done. So I'm just hopeful that now that they're in a placement that can be taken care of, because they have some significant dental concerns.
And lastly, with the holidays approaching in a couple short weeks, would you be opposed to, if we have an expanded mom's parenting time into her parents supervising, would you be opposed to allowing at least a visit during Christmas at the home of the placement?
I wouldn't be opposed to that, no.
Thank you. No further questions.
Okay, Ms. Smith, at the prelim, I had ordered that Mr. Anderson's home be investigated for placement of his child. Has that been accomplished?
So I visited the residence, and just for the record, the agency didn't receive the court order until the 6th. That's when we received it. So we were kind of going in blind on everything of what specifically was stated in the order. I did go to the home. I did visit his residence. There were some concerns that we're gonna tackle, essentially, but we don't write a physical report for a parental home. We don't do like a 5770 or a home study as we would for a licensed home. We would just run clearances on all adults who live in the home, and then we could give like a synopsis of what the conditions of the home were.
And what were the issues that you found that prevented placement of this child?
So the home, it's an older home. There needs to be, I would say, it needed to be deep cleaned. There was, I did see 2 cockroaches in the home, so we would hope that we could get an exterminator in there to help get rid of that issue. He did mention that he wanted to put new carpet in there. There are 2 very large dogs in the home. It just really needed to be kind of cleaned up. Our concern was more for the length of time that had went on between dad and his child. That we kind of wanted to strengthen that bond before we were to place him there, essentially.
I had also indicated in the court order that his parenting time was to be a combination of supervised and unsupervised. And I'm looking through the parenting time evaluation that was completed by Catholic Charities. I'm happy to provide this to you, and I would not have expected you to read it over and know it verbatim for today's hearing, but it does indicate that the 1 hour a week applies to Zachary under a professional supervised status. It doesn't appear that Mr. Anderson was interviewed during this, or that there are any recommendations as it relates to limiting his parenting time to 1 hour per week. So can you help me understand why that was decided?
That was set up with DHS. Like I said, we are more than happy to, expand that.
Okay.
I think that essentially they set up the 1 hour because at that point it had been a year and a half since he had seen his child. So they didn't want to, give a lot of parent if it wasn't going to go well. So the 1 hour did go well. Today will only be the 2nd visit that he's had. So, and it was court ordered, I believe. is it supervised?
No, supervised,
okay.
a combination of
And-
supervised and
yes.
unsupervised.
Yeah. So in the case service plan that we discussed, if we would like to increase to, unsupervised within the community for him to allow that. We just need a license, registration, proof of insurance if he's gonna be picking his son up for community visits or anything like that.
Does your company have like a parental reintroduction, reunification program? I know we've worked with Renee Moore before on a reintroduction, like a fast track reunification, assuming that there's no major issues.
Our specific agency doesn't. I know that there's a lot of different like parenting education programs that focus more, on that aspect of it, so.
Will he be referred to anything like the Orchards Family Services Program, where they'll do like the AAPI inventory of skills and kind of look at the home and help support them?
Yeah, the 16-week, the supportive visitation program.
Yes.
Yes, that's most likely what we would recommend and we would refer them.
Okay, can I ask you to tackle that referral as well as a family team meeting about his parenting time in the next couple of weeks?
Yes.
Thank you. Questions based on my questions?
No, thank you.
No, Your Honor.
No, Your Honor.
No, Your Honor. All right. Thank you for your testimony. We return your seat. Any other witnesses today, Ms. Thomas?
No, Your Honor, I just want to clarify with the court. I in my file have ICWA documentation and that it was sent out to BIA. Sorry, I just closed that and I probably shouldn't have done that. On November 15th. I'm not sure if that documentation was ever provided to the court. I don't believe that I ended up putting it in the petition. That was an oversight by me. So I just want to know if the court had it.
I don't think so.
Okay.
So I would welcome you to circulate that. It looks like we're gonna have to set an initial disposition for the Davis parents. I'm looking at Thursday, June 2nd. So, June 2nd, January. Sorry for the panic. January 2nd at 11 a.m. And perhaps you could circulate that in anticipation of our initial disposition.
Thank you, Your Honor.
Anyone not going to be available on January 2nd?
Do you need my client here?
No. Welcome to be here if you want to. Obviously, there's some issues ongoing with parenting time and some services referrals, but I trust you bring those to my attention if you need to. All right. So we'll look at the Davis parents again then on January 2nd at 11 a.m. I would assume we're going to just continue to cooperate with the parenting time evaluations and begin services in order to look at safe parenting and visitation and count on both parents independently to be working on their services to avoid those dynamics during parenting time. As it relates to your client, Mr. Brooks, we'll set out a 90-day review for him. That puts us into March. We have, how about Friday, March 7th at 10 a.m.? All right, anything else need to be addressed then for the record today?
I have one question from the first worker, just an ICWA question, Your Honor.
Okay, Ms. Grant, do you want to just step up to the podium? Maybe?
I know you probably heard my question to the other worker. Did you or anybody reach out to my client's father regarding his Native American heritage?
I did not. I must have missed that during the initial hearing. I do know he had asked for his sister to be put on the placement, like notification, but I must have missed the grandfather's information, so I can get that up.
And not for placement, this is for Native
For
American.
Native American.
So you
correct.
believe that?
So yeah, I can get, if he would provide me with grandpa's phone number after court today.
You can do that
I
after
can
court.
resubmit the paperwork, and then I do have court this afternoon. If I can get a hold of him before this afternoon, I can resubmit the new updated paperwork then.
Oh, there may be no update. I just don't know.
Yeah.
Thank you. Nothing further.
Anyone else have any questions for Ms. Grant while she's up here?
No,
No. Okay, thank you.
I have one comment to make. My client has anticipated the next step following this, and apparently is making plans or already has started the process of getting a hearing before the friend of the court or the circuit court judge on custody issue following our procedures being complete.
I do have one comment, Your Honor.
All right, I was about to ask everybody if they had closing
Oh,
comments.
thank you.
Is that okay? We.
Yeah, I
stay in
didn't know
order?
whether. we were
I don't wanna miss anybody. Sometimes it happens. So let's start with Ms. Thomas. Any comments in closing?
Thank you, Honor. I do not have any at this time. Thank you.
All right, Mr. McFarland, go right ahead.
You know, my client is under a new prescription of Zoloft, and I know he's been smiling up here. He didn't want the court to think that it's lackadaisical or anything like that. It's just adjusting to his new medication, Your Honor. You want me to express that? Yeah.
Thank you. Comments, Mr. Brooks? Any or anything else?
Hell, I've been taking it for 25 years. It works fine with me.
Mr. Burns, any comments?
Thank you. No.
Ms. Underwood?
Your Honor, the only thing I would like the court to address, and that might already be appropriately addressed through foster care, is to consider additional parenting time for the holidays, specifically with regards to Miss Davis and then Tyler Anderson and his child. I would also encourage foster care to continue exploring the potential of maternal grandparents supervising mom's visitations in a structured way if it does not put the children at an unreasonable risk of harm, and the children can continue to be safeguarded during that time. Thank you.
Okay, well, we'll trust Ms. Smith to tackle that in addition to the FTM about parenting time for Mr. Anderson. Thank you. And I want to just say, I don't want either parent talking about these proceedings or any criminal proceedings or anything else to these children. I have read the parenting time recommendation. I'm aware of the dynamics and the downplay of some of the incidents that have happened that led to the court assuming jurisdiction over this family. So I just want to encourage both of you to really focus on having a good experience with your children, demonstrating the highlights of your parenting skills, and just enjoying that time and not talk about what's happening on the other side of things or even your services. So politely, but firmly redirecting the conversation about that if your child brings it up, and we'll count on you to be adults about that and for our monitors to be watchful of that as well. I'm going to follow the parenting time recommendation continuing forward. There is a recommendation in here for therapeutic supervised parenting time. It looks like for Zachary. Ms. Smith, is that something that is happening? I'm sorry if I missed that already.
I have made a referral internally. I'm waiting to hear back from Ms. Millenbach. She, I believe, has a wait list, but she said that she should have some openings in January.
That would be great. Yes, she's an expert in that area. So that'd be great if we could get her.
That's it.
Okay. All right. All other orders will remain in full force and effect. The children are in the least restrictive environment, considering the issues that were identified need to be tackled by the parents today. I've outlined what I'd like to see for Mr. Anderson moving forward, as well as the Davis parents. Did you agree with Ms. Underwood also that that issue of potentially some supervised parenting time with mom and her parents could be explored? So I'm asking Ms. Smith to conduct a family team meeting or two if that's what's necessary, one for Mr. Anderson and one for Ms. Davis on that point. I think Mr. Davis has to continue with his work and get into that referral before we can really expand anything for him. Based on what I'm looking at right now, at risk level appears to continue to be rather high. I'll look forward to any updates on the criminal cases. The other thing I wanted to say to you and your client, Mr. Brooks, is that his case is currently assigned to Judge Olsaver. And so you may want to also look at requesting the case be reassigned to this court so that I can handle everything given the circumstances rather than asking Mr. or Judge Olsaver to review everything.
I was unaware of that, Your Honor. I'll deal with it.
Yeah, I just checked on that, so. All right, we'll see you all back here. Well, not all of you, but we'll see the Davises back on January 2nd at 11 a.m. And likely your first regular review will be consolidated on March 7th at 10 a.m. So please take note of that as well. But that will be Mr. Anderson's first regular review. And unless there's any questions, that's all for today.
Did they wait for an order, Your Honor?
Those won't be ready today, but
Okay.
it does look like I have valid email addresses from everyone. So we'll get those to you in the next couple of days. Is the date and time for the initial disposition as it relates to Zachary Davis and Brianna Davis. So may I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, lawyer guardian ad litem for the minor children.
Ms. Saja Thomas, counsel for the department, foster care worker is, sorry, were we talking over one another?
Apparently, Mr. McFarland has other places to be.
I don't know how that's popping up.
You can't leave yet.
Ms. Kristen Smith is present on Zoom for the agency.
Kristen Smith, foster care worker, Catholic Charities.
Thank you. All right, Ms. Underwood, whenever you're ready.
Your Honor, I was able to meet with the minor children in person at their relative placement. It was also nice. It was at the time in which Mom was having some parenting time, so I got to see her interact with her kids. The youngest child was struggling a little bit, just being a typical, I would say, toddler at the beginning. So nothing that I'm not used to seeing with respect to kids, but he warmed up to me again pretty quickly, and he seems to be adjusting well and doing well in his placement. The middle child, the daughter, is very friendly and wanted to, again, come hang out with me and show me all around the house and color and just do a lot of fun things, and wanted to make sure her mom and her little brother were included. So she's doing very well, seems to be adjusting well, and thriving where she is. I think a lot of that's also due to the fact that all the other regular things in her life haven't changed. Other than the placement, she's still going to the same school and has that same the same family around. The oldest child is also doing very well. He seems to be happier in school than he was the last time I talked with him. Things are going better there, and was very excited to tell me that visits with his dad, which are occurring in the home of the placement, are going really well. So I'm happy to hear that as well. But children are in their least restrictive environment. Having them remain in their placement at this time is in their best interest, and I would just recommend that the court continue the placement.
Thank you. Testimony today, Ms. Thomas.
Thank you. And I'll take testimony from Ms. Kristen Smith, please. Ms. Smith, your court report that you provided for today's hearing includes the case service plans for both parents, the family team meeting report, the psychological evaluation for Ms. Davis, and then referrals for LA and VD. With those documents, are there any updates or modifications that need to be made to them?
No, not to those documents.
Okay. And have you circulated any other documents since filing that court packet?
No.
Thank you. Today is the initial disposition for Mr. and Mrs. Davis. Did you have the opportunity to review the proposed case service plans with them prior to this hearing?
Yes, I did.
Were they able to identify any additional needs that needed to be worked on throughout your meeting with them?
Not at this time, no.
Okay. And do you believe that the proposed case service plans as presented are adequate to address the conditions that cause the children to come into care?
Yes, I do.
Since, or I guess before today, are there any voluntary services that the family has engaged in?
Other than the ones outlined in the report?
If you can just highlight those, please.
Sure. So both parties are currently engaging in services at ACPC, and they are receiving marriage counseling and then medication management, and then Zachary is also receiving individual. And then Zach is also engaging in anger management and domestic violence counseling with Sally Welsh through Recovery Road. He also has a 24/7 ankle alcohol monitor. That's through, not probation, because he hasn't went through like the sentencing yet, but it's through the court. And then referrals have been made for the parents for the foster care supportive visitation program. For Miss Davis, those started this week. And then I believe next week is when they will open services for Mr. Davis. And then I just made a referral for a psychological evaluation for Mr. Davis yesterday. It was accepted, but I haven't received the date of the appointment. And then for the kids, therapy referral was made for the oldest two children, for our child therapist, Pam Millenbach, and she was with them, I believe last week.
Ms. Smith, you're kind of cutting in and out a little bit. Could I ask you just to move a little closer to your microphone, please?
Yeah.
I caught that. Thank you. Pam Millenbach is doing some counseling for the oldest two children. And what did you say after that?
Just that I believe that services started last week. Ms. Millenbach just started.
Thank you.
Wonderful. I know that the psychological evaluation for Ms. Davis is attached to this report. Have you had the opportunity to review that with her?
I believe so, yes.
Okay. And are there any referrals that need to be made based on that report, in addition to the ones that you've already done?
Without reviewing it right now, I'm not sure.
Okay.
I believe most of the recommendations that were in it are services or referrals that have already been made.
Okay. And then how's parenting time going so far?
Parenting time's going well for the most part. Miss Davis, we did have an FT, I believe it was before Christmas, when we increased visits and expanded them to the relative's home. So Miss Davis does visit with the kids more frequently, for longer durations. I know that she's had some difficulty with some of the behaviors, but she's working well with the service provider to assist her. For Mr. Davis, his visits are still based on the recommendation from the parenting time evaluation with the one. His visits are going well. However, he's had 2 visits now that if the kids are difficult or not listening, he has essentially threatened them that he won't come to the visit the following week. So that's new and that I haven't had the chance to address with him. The first time it happened, I was going to kind of let it, I don't want to say let it slide, but then it was reported that it took place this week as well. So it's hopeful that now that we have Pam Millenbach involved, that she's going to be able to assist the family more specifically, during parenting times as well.
And this case or plan is it address, or I'm sorry, is the goal for this family still reunification?
Yes, it is.
Okay. Sorry, dogs are barking. And currently, what would be the barriers to reunification with the parents?
At this point, it is still a concern for the domestic violence in the home. I know that the parents are planning together. However, I think that both of them do need some therapy, which they are engaging in. Also, substance abuse just with alcohol. It seems that specifically is an issue with Mr. Davis. However, it's been also an issue with Mrs. Davis, as a lot of the arguments have surrounded around that as well.
Okay. And otherwise, these parents, they have employment or sufficient income to meet their basic needs and care for their children?
They do, at least they have reported it. I'm still waiting for verification of employment. I have been to the home. The home is appropriate. They did provide the lease. They are current on that. So they are paying bills, making ends meet, but still like verification of how that is being met.
Okay. And as it relates to the children's well-being, is there anything that you'd like to highlight from your court report?
I don't think so, not at this time.
And is there anything else regarding this case from your knowledge, or any of the documents you've provided that you'd like to bring the court's attention to?
No, not that I can think of.
Thank you. With that, Your Honor, I have no further questions of Ms. Smith and would move to admit the court report with the attachments.
No objections.
No objection.
Thank you. They are received. Could you clarify exactly what, if the ICWA Native American Heritage documentation, if you could just quickly outline what's in this packet on the record, please?
I did not submit any of the ICWA documentation that was explored and I believe submitted by the CPS worker. The family has identified Cherokee and we are waiting for the response letters.
Okay. Yes, I do reflect that this was filed in December 26th of 2024, but it hasn't been addressed on record yet. There's also a December 30th, couple of exhibits, and then the January 17th report and exhibits. So I guess I should clarify what I'm receiving into evidence. I'm assuming it's the January 17th report and exhibits, but if you could clarify on those other things, that would be great.
Yes, I believe the one that would have been submitted was, because this hearing was adjourned. So I believe exhibit 1 was only the parents' case service plan and the FTM sheet. And then that hearing was adjourned. So then I was asked to provide more of a court report and court memo. So the new one, the exhibit 2, A through G, would be the most recent.
Okay, thank you.
And Your
So,
Honor, if I
this-
may,
Yeah, go ahead.
I'm sorry, I'm sorry to interrupt. I was just going to say, if I may, on the ICWA documentation, I believe that the caseworker had provided, the CPS caseworker provided the inquiries that were sent for each of the children. And then there should have been like the certified receipt that it was sent to certified mail, but I don't have those green cards back or any responses back.
Okay, thank you for the update. Are you asking for the admission of those documents formally then?
The ICWA documents, yes, Your Honor, but the court report or the family team meeting notes and the case service plans that were submitted earlier in the month, I would ask the court to disregard those as they are part of the second packet.
Very well. Objections, counselors?
No.
Very well. I will do as requested. Those documents submitted December 30th, 2024 have been disregarded, and I will receive the inquiries and the certified mail receipts. It does indicate inquiries were sent to the Eastern Band in North Carolina, the BIA in Minneapolis, United Kiowa Band in Oklahoma, and the Cherokee Nation in Oklahoma. Questions for this witness, Mr. McFarland?
I do. I'm gonna go up to the podium where she can see me and I can view her. How many visits per week and what is the duration that mother has?
Ms. Davis has visits on Thursdays, Fridays, and Tuesdays, Thursdays, Fridays, and Sundays. Tuesdays, she visits from 4 to 5, and that is now with a supportive visitation coach. And her Thursday and Friday visits are from 4:30 to 8, and Sunday, I believe, is from noon to 7.
My client's visits are limited to 1 hour because why? I didn't hear that real clearly.
It was based on the recommendation from the parenting time evaluation. It said that it was recommended he have a supervised visit for 1 hour a week until he had started engaging in some services, which he has done, but it would be our recommendation that until the therapist has some time to really get in there and work with the family, that we keep it at that 1 hour.
So from what I'm hearing though, maybe it was him threatening not to come as maybe a type of punishment, but that was what it sounded like, right? That's not something he should say, but it wasn't any physically or mental intentional harm. Is that what I'm hearing?
Correct. The first time that it was, brought up, I essentially kind of disregarded it. Parents, out of frustration, sometimes will say, things. And then it was brought up again this Wednesday when he was having a difficult time with children, he had, told them that if they continue to act like this, that he's not going to come. So that's obviously a concern for the agency that he only sees them once a week, and that was his response to handling a difficult situation.
When you mean it was brought up, do you mean a supervisor at the first meeting told him that that was not appropriate to say?
I spoke with him and Miss Davis the next day, I believe, about that probably wasn't an appropriate thing to say. Yes.
Some of it might be a bad habit that he's trying to break. That might be a possibility, right? Just a mannerism of speaking.
Yes.
Your Honor,
that's why
I'm sorry, Ms. Smith. Your Honor, I just want to object to this form of questioning. I guess it seems like it's more appropriate as an argument rather than a question for Ms. Smith to be able to answer.
Well, it seems like a question to me, and she's answering them. It doesn't say, and that was my last question on this subject, but I don't see where it's not cross, and it is cross-examination.
All right, but you said this was your last question?
On that subject, Your Honor.
Very good. I don't think that the objection necessarily needs to be addressed, Ben, and you're welcome to move on to your next topic.
How frequently is Ms. Millenbach going to meet with my client? Do you anticipate?
I'm not sure on the specifics. The referral was just made and she just met with the family, depending on her availability. Hopefully at least once a month. She'll meet with she's going to meet the children weekly, but to be able to observe his parenting time, it would be hopeful that she could at least do it once a month.
Oh, it could be several months. Am I hearing that he might only have the one visit per week?
No,
Or
not necessarily.
Okay. I didn't mean to interrupt. Go ahead.
Not necessarily. Like I said, we're following the parenting time recommendation that was in place. So if the court orders more frequent visits, then the agency will accommodate that.
Well, that'd have to be today because typically our reviews are every 90 days. So I guess I'm asking, is the only mechanism for him to get more parenting time a recommendation from Pam Millenbach? Is that what I'm hearing or not?
No, I think that it's early in the case and that I think his engagement in services should continue.
Okay, I guess I don't understand that answer. I guess my question again is Ms. Millenbach the only one now other than the court who would control when his parenting time is expanded, or you have that authority?
I wouldn't say I have authority. I would say that would be up to the court. I would look to Ms. Millenbach for direction. She hasn't observed dad with his children at all yet. So I can't say when Pam will feel parenting time should increase.
Okay, nothing further.
Any questions, Ms. Dumont?
Ms. Smith, would Ms. Millenbach then be able to determine if Mr. and Mrs. Davis would be able to have therapeutic parenting time together with the children?
Yes, we would also look to her for that. As long as the parents are continuing to plan together, then yes.
Okay, perfect. And then it seems as though Mrs. Davis has started on the majority of all of her case service plan. Is there anything specific that you want her to focus on?
I think the only thing that we haven't had a chance kind of to talk about was just for her to engage in the Al-Anon meetings. I think that would be beneficial for her since she has been in a marriage where alcohol has been an issue for some time. I think that would be a beneficial service for her.
And then with regards to her parenting time being supervised and unsupervised, you are just saying that is left up to the recommendation of a therapist at this time.
Yes, and for the agency to have the discretion. I do know that it has been asked, for her to have some unsupervised time with the kids at the relative's house, just to help them, as both of them they work full time. So it would be helpful if mom could come over and help them get ready for either school or daycare. So the agency was just asking for the discretion to allow that. We would not at this time be looking to move unsupervised visits into their home. It would be strictly unsupervised visits at the relative's home.
Okay, but you predict that that would be coming shortly, unsupervised at the relative placement?
Yes.
Okay, thank you, nothing further.
Questions, Ms. Underwood?
Has the department considered having trauma assessments completed for the children?
Yes, we have. I have not gotten around to making that referral yet.
And in the report, I believe there were indications about Mr. Davis having a sister or a relative that would be willing to take the children if needed. Is that correct?
Yes, that is correct.
Would she be an appropriate person to consider for maybe respite care so that the placement would be able to have an occasional evening when the children could maybe stay with that relative?
We haven't had the chance to run essentially their clearances. So I can't say whether or not they, that she would be appropriate. I know that we have talked about her and her husband becoming a support, a support person for the family. So yes, as long as we were able to run those clearances, that has been.
Okay, is that something that the department or that you'd be able to move forward with?
Yes.
Okay. I don't have any further questions. Thank you.
Okay, what's happening with the directive to do a home study in the home of Tyler Anderson?
So I've already been to Mr. Anderson's residence. There were some concerns that were discussed at his initial disposition that he's working on.
Well, the order from his initial disposition indicates that a home study was ordered and that it needed to be provided to the court, and that was also ordered back in December at the time of his adjudication. So when exactly did the home study occur?
We don't do, it's not a formal home study for a bio parent. We visit the residence and we go out to the home. I can look and get the date from when that took place, if you'd like.
Yes, Ms. Smith, please. It's been ordered twice at this point, and I really am expecting an actual formal home study and to circulate that home study as it relates to Mr. Anderson. And this will be the third time I've actually ordered that. So please make sure that that gets ordered and circulated.
Could you
also tell, thank you. What?
I was just gonna say, could you specify, like I said, we don't have a formal home study that we do with bio parents. And there's not a document for it.
Okay, I'm gonna leave that for you to talk with Ms. Thomas about, because, okay. So part of the reason for that was that Tyler Anderson was seeking placement of his son. And as I understood it, essentially the holdup was the home study to determine what was going to be happening. And then there was supposed to be a referral made to facilitate reunification between him and his son. So it's very concerning to me that the child is still in placement and not returned to the parent. And I don't have an update on why that's not happening. So can you be more specific about the issues that you found in his house at this point?
Yes, there were roaches found in the home. There was a concern as there's another child in the home. At that time, Safe Sleep wasn't being used. I was waiting for verification of employment. And the home was also in pretty poor condition. Mr. Anderson had stated that he was in the process of getting things fixed up. We have provided him with a dumpster service if he needs it. And DHS said that they would help pay for an exterminator, and I'm waiting on him to provide me with 3 different quotes that way we can assist him with that.
All right, and the referral to engage with counseling with his son, where's that at?
Miss Millenbach is working with his son.
And Mr. Anderson?
Yes.
Thank you.
The referral was made for him for the supportive visitation, the parenting education as well. I apologize. I was under the impression that this was specifically just disposition for the Davis family. That's why I didn't specify anything there as relates to Mr. Anderson.
I'm only bringing it up because I've had to order it twice up to this point, and obviously the child is concerned by today's initial disposition and at every juncture. So that's the reason that these questions are relevant for today as well. And I appreciate you offering some of the information that's outstanding on that. Any questions based on my questions, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
Well, thank you.
No, Your Honor. Ms. Omen? Okay. All right, any other witnesses, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
One moment. You go testify. No, you are.
No witnesses, Your Honor.
No witnesses. Okay, comments in closing, Ms. Thomas?
Thank you, Your Honor. First, I would like to apologize to the court as I had instructed Ms. Smith that this was only relating to Mr. and Mrs. Davis, as Mr. Anderson and his attorney were not present and this wasn't noticed for him. So I apologize for that. We understand the court's instructions very clearly and will work diligently to get that information submitted at the next review hearing. Otherwise, we are just asking the court to enter this case service plan as it relates to Mr. and Mrs. Davis so that the goal can remain and they can work towards reunification. It seems that there are, several services that they are already undertaking, which is really promising and really nice to hear about. Ms. Smith also seems to have a very good understanding of the family's needs and getting their referrals made. If we could set this with the next review hearing, I think it might, be beneficial for all of the children. So all of their parents are being addressed at the same time. And then as it relates to parenting time for dad, I think that Ms. Smith would be guided by the LGAL, but also reports from the multiple service providers, specifically Sally Welch, who is working with dad on domestic violence and anger management. I will ensure that that service provider has the parenting time assessment that was completed before the court was involved to hopefully utilize that person as a guiding light in parenting time. So we just ask the court to specify in the order for the bio-parent home assessment. And then for parenting time that we continue to follow the parenting time recommendation until there are reports and recommendations from service providers. Thank you.
Comments, Mr. McFarland?
Absent from any commentary about my client's visitation was any anger management issues. So I think we can infer that what he said to the child was said in a pleasant tone, but he understands that it's not what you should say. And bad habits are sometimes hard to break, but it's not malintent, Your Honor. The tone of voice, there's nothing indicating that it was meant to be scary or mean. Only concern is that if Ms. Millenbach only observes once a month, it'll be multiple months down the road until his parenting time is expanded, Your Honor. So, or that there's going to parenting time with both parents. And I haven't heard any negative commentary from the guardian ad litem, at least regarding my client's visits, Your Honor. So we would like at least to have expanded parenting time in the end. Thank you.
Your Honor, Mrs. Davis's number one goal is to get her children back. She's been compliant. She's started pretty much every single thing on her case service plan, and she will continue to do that between now and the next review. We will work with the department on getting unsupervised parenting time and maybe some joint parenting time based on therapist recommendation. And she will just continue to work towards getting custody back.
Ms. Underwood, sorry, I'm reading documents and, go on.
Your Honor, we're still very early on in this case, but I will say that I'm happy to see that visits with mom are going well. I do have concerns with some of the things that I read in Ms. Davis's psychological evaluation. However, I do recognize that she is seeing a therapist and working through some of those issues that she expressed in that evaluation. I would leave the unsupervised visitation at the discretion of the department, as well as, again, the service providers that are in and out of that home on a regular basis. I don't feel like it's appropriate for the parties to have joint parenting time at this time. I think that dad needs to gain some parenting skills and parenting abilities without relying on Ms. Davis to do the majority of the parenting at this point. Mr. Davis is only, I believe, again, as of the date of the report, I think it was maybe 5 out of 26 of one of the classes that he's been doing, and he's just getting into some of the others. So I think that additional resources, I think the Orchards program will be beneficial for both parties, and especially Mr. Davis. But I would recommend that parenting time were to be expanded for Mr. Davis, that it be still under supervision, and again, not with Ms. Davis at this time, so he can continue to learn and apply the skills that he is hopefully gaining throughout this process toward parenting his children.
Thank you. The court finds all interested parties are given notice for purposes of today's initial disposition. The parenting time evaluation will continue to guide the progress of the case as it relates to that. In that, it is important that both of these parents, frankly, engage in their services and learn some new skills and some new ways to look at the dynamics both in their relationship together and in their interactions with their children. For example, the dynamics that were very clearly abusive in a home as a result of Mr. Zachary Davis's decisions, Ms. Brianna Davis didn't see a problem with. There were very clearly child abuse actions being taken that Brianna Davis did not see as abusive in any way, shape, or form. That's concerning. In short, I agree with Ms. Underwood that the parenting time will continue to be separate. It will continue to be at the discretion of the evaluators, Ms. Abbott or Ms. Millenbach, moving forward. The comments that were made by Mr. Davis during the parenting time are indicative of the control and abuse dynamics that he needs to work on. So we're going to continue to follow the recommendations of Ms. Erin Abbott until and unless she or Ms. Pam Millenbach advises that it's in the children's best interest moving forward for them to see their parents either together or at a more frequent rate. I also think I'm interested in seeing the trauma assessment and understanding how the children are doing around parenting time and whether or not that's causing them, triggering them on any of the incidents that they've been through. They clearly need to heal, and both of these parents need to develop some serious skills and at least the perspective to understand the problems in their household so that they can provide a safe and stable environment for themselves and the children that they have between them. I do find that reasonable efforts towards the goal of reunification are being made, spearheaded by Ms. Smith, who is making some good referrals and staying on top of things. I had obviously a few questions on some aspects as it relates to the oldest child concerned in the case, but overall, I do find that certainly her efforts are being very timely made, in fact, as well. The case has just been opened in November. And these parents are both in some good services in order to try to start working on these things in order to gain more parenting time. And that is to her credit. She's been able to get those referrals in place over the holidays, frankly, and in such a short period of time. Ms. Underwood is certainly in satisfaction of her obligations as a guardian ad litem. And the children remain in the safest and least restrictive environment under the circumstances. Those abuse dynamics, both between Mr. Davis and Ms. Davis, as well as between Mr. Davis and the children and Ms. Davis's understanding of those issues remain a serious risk of harm associated with returning the children to their care at this time or even expanding parenting time. So we'll have our next review hearing in 3 months, which will also be a permanency planning hearing. Children have been removed since 11/21 of 24. It will be time to begin having those permanency planning hearings. Children will have been removed out of the home of their parents for 6 months at that point. And also I need to make sure that the parents are serious about changing the dynamics of their relationship as well as the dynamics of their relationship with their children. I'm not seeing that so far, either by the reports or by my own observations today, given the reaction that I'm seeing by the parents today to the comments that were on the bench and also by Ms. Underwood and the caseworker. So I would encourage them to be more engaged and understanding of the serious issues that are in their family and working on those. And continue to do that.
Left out.
Okay,
There was
Mr.
more.
Davis, again, interrupting during a court hearing is a sign of control tactics, okay? So I'm gonna encourage you to try to learn about that with your counselor and try to understand and respect the processes that are in place for you to be able to reunify with your children. We'll have our next review in April. I'm looking at 10:30 in the morning on Monday, April 21st. Are there any issues with that date and time?
There you are.
No, Your
Very
Honor.
good.
Thank you.
Very good. We'll see you then, unless there's any hearing for all 3 parents concerned. May I have the names of our participants, please, beginning with our guardian ad litem.
Good afternoon, Your Honor. Nicole Underwood, lawyer, guardian ad litem for the minor children.
Nastasia Thomas, counsel for the department. Ms. Smith?
Kristen Smith, foster care worker, Catholic Charities.
Michael Brooks, I represent one of the fathers, Taylor Anderson. Mr. Anderson,
I'm Tyler Anderson. And
excuse me.
Good afternoon, Brian Fry, appearing for Brianna Davis. I am appearing on behalf of her attorney, Katerina Dumont.
Brianna Davis, mom.
Good afternoon, Your Honor. Matt Raines appearing on behalf of the father, Zachary Davis. Mr. Davis, would you please identify yourself by stating your full name? You'll need to unmute your device, and I'd request that you activate your video as well.
Zachary Davis, father.
Thank you. Excellent. All right, Ms. Underwood, let's go to you first for your report whenever you're ready.
Thank you, Your Honor. I was able to meet with all children during this reporting period. I will start with minor child L.A. He is the child in common with Miss Davis and Tyler. He is thriving, being placed with dad. He is doing very, very well. You can tell he's got a great relationship with him and is very bonded with his dad. He started attending a new school based on where he's now living with dad. He's doing very well and continuing to progress with Pam Millenbach and in therapy. And again, despite there still being, hiccups along the way and typical sibling issues that are being worked through as any family would have, he's doing very, very well. He enjoys being with his dad. He also has expressed that he has liked going over to visit mom and spend time with her at her new residence. But he would like to primarily at this time stay living with dad, but does want to see mom often and spend a lot of time with her. Upon the custody agreement being placed in the in the custody file between those two, I would recommend releasing Mr. Anderson and the child from this case, assuming that he'll continue in therapy with other services. The younger 2 children are doing well in the family placement. They have also made lots of progress, especially the daughter. She's been working very well with Pam as well and learning lots of coping skills and just skills that will help her process her traumas and be able to function more properly. She's in school now as well. She was excited to talk about that. Visits seem to be going well with mom and I would recommend and support the department's position to transition the children into the care of their mother. At this time, as she has done very well and worked very hard to get herself in a place where she can take care of and keep her children safe. The younger children don't have the ability to express preference based on their age, but I would recommend, again, that the court consider transitioning them to reside with their mom at this time. Thank you.
Thank you. All right, Ms. Thomas, or actually, let's go to the attorneys. Any comments before we get into testimony?
No.
No comments.
Not at this time, Your Honor. Thank you.
Your Honor, all I would indicate is, because I don't believe that this had appeared in the updated court report, is that with respect to my client, Zachary Davis, there has been a resolution of the criminal charges against him. There has been a plea of guilty that has been entered to one misdemeanor count of reckless discharge of a firearm. That is with a sentencing understanding of probation with no upfront jail time. There would be other conditions that are part of that, which would include the use of no alcohol. Mr. Davis has previously been on a tether, and I think he was wearing that for an excess of a year as bond conditions. That has now been released from him as well once that plea was entered last week. Mr. Davis does await sentencing on that matter, and so I don't want to advise the court as to what the sentencing will be, but there is certainly an anticipation regarding the sentencing that is along those lines. That's a development that I wanted the court to be aware of, but nothing further.
Thank you. What is the date for sentencing?
Your Honor, we have sentencing scheduled on October 3 at 8:15 a.m.
Thank you. All right, Ms. Thomas, your first witness.
Thank you, Your Honor. I'm just going to call the parent briefly, so I'd ask Mr. Anderson to be sworn in.
All right, Deputy Ames. Mr. Anderson, come on up to our witness stand.
Hey, Mr. Anderson, how are you today?
Doing okay.
Good. Did you have an opportunity to review the report that Ms. Smith provided for today's hearing?
Yes.
And are you in agreement with everything that is in it?
Yes, I am.
Okay. Is there anything that you need from the agency to continue to support your child in your care at this time?
No, everything that's been provided so far has really helped me out a lot. All the programs, honestly, I've learned a thing or two about them, and I've been able to help the programs themselves with adding things to their repertoire. So, no, honestly, I feel like the programs do what they're supposed to. And,
And do you anticipate a custody order, an agreement on custody for your child to be entered relatively soon with Ms. Davis?
Yes.
Okay. As it relates to your child, the reports indicate that he's been with Ms. Mellenbach and doing very well with her. If the court were to terminate jurisdiction, would you continue to bring him to Adrian so he could continue his work with her?
I would try to see if there was somebody that I could go through a program out in Jackson. But
okay.
It'd be on the recommendation from Pam herself.
Okay.
For that to go through. Until then, yeah, he would definitely go and see Pam.
Okay. So you'd be looking just more to transition into someone else with the guidance of Ms. Mellenbach?
Yes, yes. So it's kind of a coincidence. The school that he goes to, the therapist there, she used to work for Pam at her office. So there's a bit of a transition that we're going to try to see what we can do there. But yeah, with the recommendation of Pam.
Okay. And just for the record, do you know what the proposed custody arrangement would be for you and Ms. Davis related to your child?
Not at the moment, no. I don't have the court document. It would be just, I would have full custody and then she would have rights to be able to dictate whether or not he can doctor visits, be able to be picked up from school.
Sure. And what would parenting time look like? Do you know, or do you know what's proposed at least?
it'd be 50-50. I think that's what it would be considered, but I would have a majority. Like I would have them through the school year and then she would have them in the summertime weekends.
Okay, okay. All right. Well, thank you for that. Is there anything else you'd like the court to know?
No.
Okay, thank you. I have no further questions.
All right, any questions for this witness from any of our other attorneys? Mr. Brooks?
I do. Do you and the child's mother talk, or are you not communicating?
Well, we communicate all the time whenever it comes to Liam.
So have the two of you talked about post-court jurisdiction decisions, issues with respect to your mutual child?
We have not came together to sit down on a solid.
So she, for all you know, right now, as she sits there, she may just say she's going for full custody in circuit court. Is that an accurate statement or no?
She possibly could. I mean, I don't know exactly what she would like to do.
Would it be fair to say you don't anticipate that?
Oh, I don't anticipate that at all. I was like, hope not.
Because you've said two things here today, and I'm trying to nail something down. On the one hand, you say you're anticipating a 50-50 custody arrangement. And on the other hand, you're anticipating that 90% of the time you would have your son in your care. Those are contradictory statements. Do you understand that?
It would be me having my son majority of the time and us trying to figure out when the other time would come for his mother. I don't have the custody or anything written out or written in any documents at the moment, and I do apologize.
And the two of you have not discussed any particulars about this?
No, not yet, no.
I see. Thank you.
Okay, Mr. Fry, any questions?
How you doing today, Mr. Anderson?
No, pretty good.
Good. So you and Miss Davis get along pretty well?
For the most part, for Liam, yeah.
And you can co-parent Liam well together?
Yeah.
Okay. And when you said 50-50 custody, you were talking about legal custody and decision-making type things, is that right?
Yes.
Okay. But you anticipate that he'll primarily continue to reside with you?
Yes.
Okay. And parenting time, will be something that you and Miss Davis work out?
Yes.
And that's what you've been doing,
Yes.
during the pendency of this case? You just continue that, right?
Yeah, we've talked to each other all the time whenever it comes to Liam and what days she should come up, what school supplies he would need, just general things that he would need for my house if he needs any. We always have contact with each other just to make sure that everything goes smooth for Liam, and it's been going pretty smooth. I have not had any problems. There's been no disputes, no anything, and it's been going pretty well.
Okay, thank you. I have nothing further.
All right, any questions, Mr. Raines?
No questions, Your Honor.
Ms. Underwood?
No, Your Honor, thank you.
Ms. Thomas? Any redirect?
No, Your Honor, thank you.
All right, thank you for your testimony. May return to your seat. Our next witness, Ms. Thomas.
Your Honor, I'll call Ms. Davis.
Davis.
Good afternoon, Ms. Davis. Have you had the opportunity to review the court report that Ms. Smith provided for today's hearing?
Yes.
Okay. Is there anything in the report that you do not agree with?
No.
Okay. It looks like you've accomplished pretty much all of your goals. Congratulations on that. Is there anything that the agency can continue to support you in?
Just basically the help with DHS is what I need right now because it's kind of confusing and stressful.
And do you mean like public assistance help trying to navigate like my bridges and whatnot?
Yeah, because I have a really bad time with everything getting shut off whenever I change something. So.
Okay. All right. And the recommendation seems that Ms. Smith has recommended the children be returned to your care. Are you ready for the two? Let me phrase that. Ready? Wow. Ms. Smith is recommending for the two younger children to be returned to your care. Are you ready for them to be in your home?
Yes.
Okay. And would there be any changes to their learning environments if they transition to your home?
No, right now I would be taking them to and from school and daycare. I'm currently waiting to hear back from a job, so I might just be taking them to daycare, and then Victoria, or one of them will get on the bus and go to school that way. And then my mom might have to pick them up afterwards because it's long hours.
Okay. And what was I going to ask? As it relates to your custody arrangement with Mr. Anderson, you heard his testimony, correct?
Yes.
And are you on the same page as him? Like your child would primarily live with Mr. Anderson during the school year, but you guys would figure out parenting time in which maybe you would have like the summers or liberal parenting time on weekends and whatnot?
Yes. Currently right now I've kind of been going based off of how Liam feels. I'm not allowed to say his name. Just because he has said to me before that he has missed a lot of time with his dad in the past, and he's really enjoying his time with his dad. Also, I know that the younger two get on his nerves, and so I've been trying to take into consideration how he feels instead of trying to force him to come see me because I want to see him.
Okay. Or would you be comfortable with our court releasing your oldest child and Mr. Anderson from jurisdiction today? So they would not be part of these proceedings anymore?
Yes.
Okay. And then as it relates to your two younger children, do you have any updates on like are you still in the process of divorcing and establishing custody, or is there any updates there?
We have no updates on the divorce. The hearing got switched until September 16th, I believe, and then the friend of the court intake got pushed out again also. So I'm waiting for a document back in the mail to tell me when the new date is and what document was supposedly missing from that.
Oh, okay. One of the things we typically do is offer something called reunification services, FRP, or Family Reunification Program. And that sort of initiates the tail end of our proceedings. And they really, it's kind of an intensive program, but they're in the home a lot to ensure that the transition for the children is successful. Is that something you would still be willing to engage in and participate in?
Yes.
Okay. Is there anything that you would really like the court to know about how you're doing, or anything related to your children?
All of that I can think of.
Okay. All right. Well, thank you. I have no further questions, but other attorneys may.
Questions, Mr. Fry?
I do, Ms. Davis.
Good.
So, where are you currently living?
In
Not necessarily the address, but what city?
Dundee.
Okay. And is that, do you have room for your two youngest children to come live with you?
Yes.
Okay. And in fact, have you been getting overnights with them?
Yes.
Already? Okay. And you've been having extended parenting time
Yes.
sessions with them during the pendency since the last review?
Yes.
Okay. Now, do you think it's appropriate to transition into them coming to live with you full-time again?
I do.
Okay. Are you ready to handle that responsibility?
Yes.
How has your case service plan gone?
I'm not currently in services at the moment. I think it's been about a month or two since I've done services.
Excuse me, Your Honor, could you instruct the witness to speak up just a little?
Sorry.
Thank you.
I haven't been in any services in like a month or two. I was released from all of them.
So is that because you completed everything that, you were required to do?
Yes.
Okay. What did that include?
Individual counseling, DV counseling. What's it called? Medication, therapy. I can't think of the rest of it.
Okay. Now, I believe you indicated that you were applying for jobs. Is that right?
Yeah, I have 2 jobs currently, but they're sales position jobs. So I did apply for another job that I should hear back no later than Thursday.
So you are employed right now, you're just looking for a,
Yeah.
a different job potentially?
Yes, I also do Instacart too, so.
Okay. And so are you able to financially support the children?
Yes.
Is there anything that you're struggling with currently that would affect your ability to have the children back with you?
No.
Do you believe the children should be returned to you?
Yes.
At least the two younger ones?
Yes.
Has there been any struggles for you in completing the services that the court had requested you complete?
No.
And your understanding that you've successfully completed everything?
Yes.
But you're agreeable, it sounded like, to continuing with the FRP?
Yes.
Okay. And have you looked into that and discussed with your caseworker and everything what that entails?
We've talked about it a little bit, yeah.
Okay. And you're comfortable with that?
Yes.
And you'd be able to get the kids to any appointments or school or anything else they need to get to?
Yes.
You're committed to continuing doing those things?
Yes.
Perfect. I have nothing further.
Okay, Mr. Rains, any questions?
Yes. Good afternoon, Ms. Davis. You've testified that you are seeing the two younger children at this time. Is that correct?
Yes.
What is that schedule that you're seeing the children?
So right now, I can have up to, I think it's 4 or 5 days consecutively. So I get them as often as I can. Sometimes it's split up if there are other things going on, but I get them often.
Have you
It's not
had,
on a schedule.
sorry, have you had as many as 4 consecutive days and overnights with both of the younger children?
Yes.
Approximately how many times would you say that you have had that?
Since I think it's only been a couple of times where they've been consecutive, but there's typically only like a day in between.
All right. Well, so to be clear, though, you have had at least one period of time where you've had 4 consecutive days?
Yes.
Have you had a 5 consecutive day period?
I don't think so, no.
All right. My understanding from a review of the exhibits that were submitted is that you have participated in individual counseling with Michelle Palmer. Is that correct?
Yes.
Has that been discontinued?
Yes.
When did you last see Ms. Palmer?
I don't have a specific date, but I know it's been over a month.
Might you have last actually visited with her May 27th and done a telehealth visit with her at the end of June?
Yes.
Have you been prescribed any type of medications for any mental health conditions?
Previously, yes.
Those have been discontinued?
Yes.
Have those been discontinued at the advice or direction of a mental health provider?
Yes.
Are you seeing any type of mental health provider for ongoing services or support regarding any mental or emotional health condition?
No.
You've heard the statement that I made at the beginning of our proceedings about Zach Davis and the resolution of the criminal charges against him. Did you hear that?
I did.
Is that your understanding as well, is that there's been a plea to 1 count of misdemeanor and the remaining charges were dismissed?
Yes.
Is it your understanding also that the bond conditions up until our sentencing that's approaching will allow you to have communication with Mr. Davis only regarding the children?
Yes.
Have you been having communication with him about the children?
Not since a couple weeks ago.
Okay. And why is it that you're not having communication with him?
I prefer not to communicate, and he hasn't put forth the effort to see the kids.
Where you're living, you've indicated it's in Dundee. Do you reside with anyone other than the children when they are with you?
My best friend sometimes stays there.
Who is that best friend that stays there?
Dylan.
His name is Dylan?
Yes.
What's the last name?
Rice.
And I'm sorry, was that Rice as in R-I-C-E?
Yes.
Is he regularly spending overnights with you at the home?
With me, he has been. He's not always there when the kids are there, but he's there often.
He has spent time overnight with you at that residence when you have had the children there for overnights?
Yes.
Anyone other than Mr. Rice who has stayed with you at the home on an overnight basis?
No.
Those are all the questions that I have for you. Thank you, Ms. Davis.
Ms. Davis, has your bestie been looked at by Ms. Smith and approved to be around you and your kids together?
Yes.
Okay. Also, is there a pending court hearing on your case with Mr. Anderson at all?
You mean for front of the court? No, we haven't filed it yet.
Okay, because the last order that I have indicates that you have sole physical, sole legal custody. Is that your understanding?
Yes.
Okay. Do you two plan on talking about putting a stipulated order together or an agreement, or are you waiting for the hearing? What are your thoughts?
Me and Mr. Anderson. So my thoughts were basically just keep it how it is now because Liam seems to be doing very well. And we have talked about it too. We just haven't like gotten down into the details of it yet. And I figured that would happen once we do the front of the court stuff.
Mr. Brooks?
Yes, ma'am, the line of questions I'm about to present to you are for the purpose of identifying any potential problems and see if we can avoid them now rather than have to address them again later. You understand?
Yes.
You and Mr. Anderson were never married, is that right?
Correct.
Is my client the legal father? I assume he's the biological father, but is there any documentation that he is this young child's legal father?
Yes.
And how is that established?
Birth certificate.
Birth certificate. Where was the child born?
Bixby Hospital.
In Michigan.
Yes.
Do you understand that under the laws of the state of Michigan, that birth certificate does not establish his legal status as a parent?
Well, Mr. Brooks, I just want to remind you that there is a custody order out already that establishes your client as legal parent of his child and awards this mom primary physical and legal custody.
All right, thank you.
You're welcome.
Once this judge releases her jurisdiction over this aspect of your case, the only thing left out there will be, as she mentioned, the court order. Is that right?
Yes.
And that gives you, as I understand it, primary custody of this child. Is that correct?
That's what it sounds like. I don't know.
Is it your intention to pursue primary custody of this child?
No.
You understand it may be necessary for the two of you in conjunction with each other to go back to court and come up with some kind of stipulated agreement as to what that's going to be, okay?
Yes.
Otherwise, my client pretty much is at the mercy of whatever the official documents say.
Yes.
And you don't intend to do that to him?
No.
How old is this child?
Almost 10.
7?
He's 9.
Pardon?
He's 9.
He's 9. And how long has he been with his dad?
3 months.
3 months? 3 months, did you say?
I think so.
Okay. Is this physical custody arrangement acceptable to you?
Yes.
If it's no, I'd like to hear the straight answer. But apparently it is acceptable to you, right?
I believe it's in the best interest of Liam and his mental state.
Okay. You understand that when we talk about custody, there's 2 types of custody. There is legal custody, which virtually everybody gets, which is there must be joint decision making. If you decided you wanted to raise your boy in a certain faith, you both have an input into that, correct?
Yes.
And if he did the same thing, in terms of a religious preference, he'd have to confer with you on that. Do you understand that?
Yes.
If there were medical decisions to be made that were significant, same answer. You both have a say-so whether this should be done, not done, or maybe in a different way. Do you understand that?
Yes.
That's regardless of who has primary physical custody. Now, when the judge, if the judge releases custody here, her jurisdiction in this case, there will be, at this point, no referee pending any dispute that you two have about custody currently on the books. Do you understand that?
Yes.
Have the 2 of you talked about this issue amongst yourselves?
Minimal, but yes.
I'm sorry?
Minimal, but yes.
Is that because you 2 of you don't want to talk to each other, or what?
No, we're both pretty much on the same page and we kind of established that. But we communicate really well as far as things with our son.
You 2 can go back and forth even if you don't totally agree on everything. Is that a yes?
Yes.
So what is your understanding? Let's assume the judge today releases you and this gentleman and your mutual child from the jurisdiction of this court. What do you think is supposed to happen here? Number 1, of course, you'll have mutual custody of the child. Legal custody. You understand that?
Yes.
What about the physical custody arrangement?
I would expect him to remain with his dad.
What are we talking? Every week, all week, half the time? What are you anticipating?
So given his current mental state and his situation, and I give him a say-so, I have been allowing him to come see me whenever he wants to, and putting it in front of him like, hey, I want to see you, but if you don't want to, it's okay. Like, just giving him that choice, saying that.
You're referring to your child?
Yes.
Well, let's assume.
Mr. Brooks, I think I can help you with this here.
Thank you.
What I intend to do for your client and Ms. Davis is to offer a referral to mediation to work these issues out, to see if they can't come to an agreement pending our next review and get that filed and signed. It's a Judge Olsaber case. So it's not my case. It wouldn't come in front of me. Obviously, it can be accomplished in front of the court, but I'm willing to offer the venue, the mediation venue, for them to work out some of these issues before they come back, so that they have an order that works out some of these details. And of course, you'd be invited to that meeting.
I have no further questions, Your Honor. Thank you.
Are you open to that?
Yes.
Okay. Mr. Anderson, are you open to that?
Yes, I am.
Okay. All right. Do we have any questions from our attorneys online? Ms. Underwood, Ms. Thomas?
Yes, Your Honor. Ms. Davis, do you have what in a divorce file have you requested as far as parenting time for dad?
In the current divorce file, it's restricted, however, it's going to be changed when we go to court. I don't have a document for it though.
And what do you mean by it's going to change?
I'm going for full custody and that he's not to be involved.
Okay. And is it your understanding or anticipation in the criminal case that there will be a no contact order placed between you and Mr. Davis?
Yes, and if there were if he were awarded any parenting time, our communication will likely be through the parent app.
Okay. It sounds to me, based on your testimony from the questions asked by Mr. Brooks, that right now you're agreeable to giving primary custody to Tyler and have parenting time be at all times agreeable. Is that accurate?
Yes.
If I, as the GAL, were to create a proposed stipulated order that reflected your testimony today, is that something you would consider reviewing and signing?
Yes.
Thank you. I have no further questions.
Ms. Thomas?
I have no further questions, Your Honor.
All right. I'd be inclined to let her return to proceed unless anybody else has additional questions.
No.
I do not.
Great. Thank you for your testimony. May return to your seat. Ms. Thomas, any additional witnesses?
Your Honor, I'll ask Mr. Davis to testify at this time.
All right. Deputy Hughes, Mr. Zachary Davis joins us.
Thank you, Your Honor.
All right. Thank you. Hey, Mr. Davis. Did you have the opportunity to review the court report that Ms. Smith has submitted for today's hearing?
Yes, I have.
And are there areas that you do not agree are accurate?
Yeah, she never once ever puts in anything that Megan said or noted or anything like that. My whole...
Time out.
What's it
Real
called?
quick. Who is Megan?
The lady who sat in for my parenting time.
Was that through Orchards?
I don't know. It was the same place who I had to do the class through, who I got the certificate from.
Okay.
My
Did
whole
you see
experience
that
has been negative
did
so
you
far.
Okay, I'm speaking. So you need to wait until I'm done asking a question before you can answer, okay? Did you notice that there was a report authored by the the parenting time program that you were part of? Do you know that that report is in this packet?
What? Did I notice what?
That the report from Orchards Children's Services is also included in the court report packet.
Okay. I have messages, though, from Megan saying that my visits should not be supervised.
Okay. So
that Kristen never put in there. She only put in the negative stuff.
okay. Do you understand that Miss Megan Spears, her whole report is in the court report?
Okay. But I have stuff from Megan herself that I have submitted to Kristen that she did not put in there.
Okay. And so your complaint is that Miss Smith has not provided a full or accurate picture of Miss Spears' report.
Or of me in general, yes.
Okay.
She only picks the negative stuff and runs with it. That's why I've asked for a different caseworker from the beginning.
Okay. And
I told her she was dumb. I apologize. It's been downhill from there.
Are the text messages that she's included in the court report accurate? Are those text messages that you...
Yes, I told her to talk to my lawyer instead of me.
Okay.
So
and did you see the emails in which she did communicate with your lawyer and your lawyer never responded?
I've seen that those were in there.
Okay.
I asked my lawyer about that today, or the other day.
And is it so your position that you do not want parenting time if it is going to be supervised by the agency or the department?
I want parenting time. I would do it again through Megan again. I just don't want to go all the way to Adrian for no reason, where my kids have gotten lice twice. I don't want to go there. If it can take place in Tecumseh, I'll do that. If it can take place anywhere else, I will do that. I've said that from the beginning. I don't see why I'm going backwards, though. I passed the class. Megan told me I shouldn't have supervised visits, and then I get told I have to go back to where it started.
Okay.
I felt like
Do
I'm going
you,
backwards.
and have you provided Ms. Smith with proof of your income during this review period?
Yes, I have. I have it in a text message, too. She has the letter from my boss that says how much I make monthly on a salary. And she said, yes, that will work. And she still put it in there that she never received it. But I have it in text messages.
And that's been since May 29th?
Yes.
Okay. And in your housing, it looks like there's a change of housing this review period?
Yes, but I didn't tell her that.
Okay. And so would are you living with your live together partner?
Yes.
Okay. And have you offered any background checks or clearances?
He has
if
not
the children
asked.
were to, okay. Would you be agreeable to that?
Yes, in a heartbeat.
Okay. And how is it going, working towards your license? Where are you at in that process?
It's just a waiting game now.
What does that mean?
I mean, I've already paid my lawyer for it, so I'm waiting.
For what?
I don't know. I went a year without drinking, so now we're trying to figure out what the next step is.
And you are still receiving, or you were, or have completed, I'm sorry, anger management and DV classes with Miss Sally Welsh?
Yes, she put in there that it was all excellent. I did really well. Sorry if I sound frustrated right now. It's just none of this stuff seemed to have gotten submitted.
Yep, the report indicates that you've completed that, and it indicates you've completed your parent education with Orchards. And then your attorney has provided an update as to your criminal stuff. So all of that is accurately reflected.
And
then
Kristen told them to block me. Sorry for interrupting you, but I cannot FaceTime my kids anymore because they blocked me on my daughter's phone. And I don't know why. They said it's a privilege to talk to my children.
Okay. And are you involved in any individual counseling?
No.
Okay. And are you still receiving medication management from Adrian Counseling and Psychiatric Clinic?
Yes.
Okay. So the report indicates that at ACPC, your last appointment was on June 27th, but no other appointments were scheduled. Has something been scheduled that, that was missed in this report?
No, he gave me 3 months worth and then told me to call when I was out.
Okay.
It's just telehealth. I'll just call in and talk to him and then goes from there.
And then did you have the opportunity to review the psychological assessment that was provided by or Dr. Smith?
Yeah, I did.
Okay.
I said I have severe anxiety.
And do you agree with that?
I mean, yeah, I think I do now.
Okay. Okay. And what would, are there any services or any other programs that the agency could assist you with at this time?
I mean, I'd like to see my kids.
Okay.
I'm sure my kids would like to see me. Every time I see them, they're always excited. They told Megan they did not want to live with my ex-wife. They told her that they wanted to come home with me every single visit. I don't understand why I'm not allowed to see them now. And she's going for full custody for me not to even be able to talk to them is insane. And her financials, Aaron keeps calling me to repossess some of her stuff, so you might want to talk to her on that.
Is there anything else you'd like the court to know about how you're doing?
I'm doing fine. Besides this, I'm doing great. It'd be nice to have my kids.
How long has it been since you've seen your children?
About 2 months.
What might it be like for them to see you if the court were to,
I think they would be excited.
Okay. And so I
The
just want to be
last-
clear that you do have supervised parenting time that you are permitted to exercise. Do you understand that, correct?
In Adrian, I live over an hour away. Why can't it take place in Tecumseh? At a park, like it was.
Is there a reason you can't go to Adrian for your children?
I can't drive.
Okay. And have you asked for assistance with transportation?
No. Didn't know that was a thing. But I work in Tecumseh. I can get dropped off at any park and picked up at any time. And the kids were staying in Tecumseh, so it made sense.
In Miss Spears' report, she indicates that she has talked with you about needing to be appropriate with your caseworker and in your time with your children, and learn to cooperate and better express your frustrations without name calling.
Yes.
Okay. And so what have you done to continue to work towards that goal?
I stopped dealing with Kristen because I know it's just going to be negative. It's not going to go well. Why would I keep doing that to myself? You know what I mean? That's insanity. I'm not going to set myself up for failure.
Sorry, Your Honor, we had a glitch with internet there, but I did not have any further questions for Mr. Davis.
Okay. Mr. Raines, any questions for your client?
I do. Mr. Davis, you've heard the statement that I made at the beginning of the proceeding about the resolution of your criminal charges. Is that correct?
Yes, sir.
Was that an accurate statement about the resolution of those criminal charges?
Yep.
In other words, the felony matters and I believe the domestic violence misdemeanor matters, those have been dismissed in exchange for your plea to a 90-day misdemeanor reckless discharge of a firearm. Is that correct?
Yep.
You have agreed to a sentence that would include a period of up to 24 months of probation with no upfront jail time. Is that correct?
Yeah.
You're also agreeable to no consumption of alcohol. Is that right?
Yep.
Your willingness to test for drugs or alcohol. Is that correct?
Yep.
You're also willing to regularly attend 12-step meetings if recommended. Is that right?
Yep.
You're willing to attend individual counseling if that is recommended. Is that correct?
Yeah.
Additionally, you're willing to speak with Brianna Davis only regarding parenting time matters. Is that right?
And I'd like to only do that through the portal of the court.
You're referring to App Close or an app that is designed for parents to communicate through?
Yep.
With the entry of your plea, I believe that was last Friday before Judge Angelo in circuit court. Is that correct?
Yep.
Was it, have you now been released of an alcohol tether that has been strapped to you?
Yes.
How long did you wear that alcohol tether?
A little over a year.
Are there any violations for the use of alcohol on that tether device?
None, but there was one that said it triggered, but I was in court for the kids all day long, so Darren knew that I wasn't drinking.
When you refer to Darren, you mean Darren Cost, who is a probation officer in Lenawee County Circuit Court. Is that right?
Yes.
That did not result, the incident that you referred to did not result in a violation of your bond conditions. Is that right?
No, it did not. Nope.
Have there been any violation of your bond conditions while you have been on bond?
No.
let's talk about, let's talk about alcohol and progress there then. You have been discharged from Recovery Road, is that correct?
Yep.
You went through a course with Sally Welsh, is that right?
Yep. I really like Sally.
All right. And she has indicated you've completed all the requirements for both programs. That means mental health program and the AA program. Is that right?
Yep.
Your attitude in that, attendance, financial responsibility, and participation were all excellent. Would you agree?
Yep.
Do you use alcohol now?
No.
Do you use any sort of illegal substances?
Just nicotine.
You will occasionally smoke?
No, I have pouches.
Thank you.
These.
In terms of your mental health, you have identified that you are experiencing some anxiety. Is that right?
Yeah.
Some of that being situational relative to these proceedings, as well as the
Yes.
felony criminal matters that were previously.
Yes.
All right. And as it relates to that, I believe you are taking the medication Zoloft. Is that right?
No, they switched it to Alexa Pro.
And that's through ACPC?
Yes.
Are you willing to continue to follow through with ACPC to manage the medications?
Yep.
You've expressed familiarity with the updated report that's been submitted, and you have seen the, I believe the case, the case report that was authored by Megan Spears. Is that right?
I think so.
Okay, I think Ms. Spears, the only issue that she's that as to current needs under the foster care supportive visitation in-home parent education termination report, the only concern I think she's expressed is related to you having called the mother and the grandmother names during video calls. Have you in fact done that?
Yes.
And why did that, first of all, when did that happen, and can you explain why that happened?
I missed one of my visits on Jen's birthday because she didn't want to take the kids. She didn't want to reschedule because it was her birthday. She'd rather go to the lake and party. So I said she was a effing C. And that's all it was.
And I'm sorry, did you say that to the mother?
I might have said it to both of them.
Was this something that was during a video call that you had with the children?
No, I said it over text message.
Was there the communication that you've just mentioned? Is that something that somehow you believe your children were exposed to?
Not unless they said something out loud.
Okay. And this was a text? Was this just a typed text? Okay.
Yep.
Other than that, has there been any other type of communication that you've had wherein you've called the mother or the grandmother names?
I don't think so.
Counsel had inquired about you regarding parenting time. Have you in fact requested that the parenting time be exercised in Tecumseh?
Yes.
Have you been advised as to why that cannot occur in Tecumseh?
Because Kristen said it will take place where she picks.
Has parenting time for you previously been in Tecumseh?
Yep.
Was there an explanation from Ms. Smith as to why it would no longer be then in Tecumseh?
Nope.
Did the decision to stop your parenting time in Tecumseh, did that follow your hostile treatment, or your calling the caseworker dumb?
Probably.
Your Honor, are these questions leading to something relevant to why we're here?
Would you like to respond, Mr. Raines?
If that's an objection to relevancy, yes. If we're wondering about what the status is and what the progress is of Mr. Davis relative to him being involved with the children, why he's exercised his parenting time, why he hasn't exercised his parenting time, I think that all these questions are relevant.
They're relevant, but it sounds to me like they're the kind of questions you should be asking in a district court hearing after we've completed our process here.
I'm not sure what jurisdiction the district court would have regarding a custody matter.
I said district, I meant circuit.
All right, any other attorneys want to weigh in on this? Mr. Fry?
No position.
Ms. Underwood, Ms. Thomas?
I believe they're relevant as to parenting time and why Mr. Davis may or may not be following the case service plan, which requires parenting time.
Ms. Thomas?
I agree with LGAL on this matter, Your Honor.
Okay. All right, Mr. Rains, we'll let you move forward on your questions for those reasons.
Thank you. Do you recall when, sir, would have been the last time that you exercised parenting time with your children?
Yes. It was July. I think it was right before 4th of July.
Okay. You have been asked some questions about your current living arrangement. You're living at a home in Carlton now, is that correct?
Yep.
Can you describe the home that you're in?
It's just 3-bedroom house, 3.5 acres, middle of the country. We have chickens, dogs, dirt bikes. It's a dirt road. I love it. It's perfect for my kids, you know?
And you're living with your partner there?
Yep.
And can you state her full name?
It's Brianna Burgess.
And how do you spell her first name?
Brianna.
And Burgess to spell her last name?
Yep.
To your knowledge, does she have any criminal record?
No.
To your knowledge, does she have any DHHS or CPS record?
No.
Is she the custodian of any minor children?
Yes, she has 2 kids.
And are they there at the home where you're staying?
Yes.
And are those children continued to be in her care since you've been there?
Yes. Their ages are 6 and 2. And they've already met my kids.
Are you interested in having parenting time with your children now?
Yeah, I would love it.
Are you, what is your request in terms of parenting time of the court at this point?
I mean, Megan said it'd be hard on the kids to do it in home, which I get because they would want to stay. So I would just like to have it in public at least. At the very least. More than once a week for an hour too.
Do you know if Ms. Spears is available to you as a supervisor if this court thought that appropriate?
I don't know. I could ask her.
Are you requesting that there be somebody other than Kristen Smith to?
Yes.
Okay. Was Kristen Smith proposing to do supervision for you?
What do you mean?
Well, have you understood that there would be a particular person doing supervision?
Yes, Kristen said it would have been with her at wherever she picked or approved.
All right. And sir, I think there was Ms. Davis had indicated I think at the request of her counsel, who's not present today, your pretrial has been rescheduled in the divorce case to September 16. Is that right?
Yeah, I guess.
All right. Thank you. That's all I have of my client. Thank you.
Mm-hmm.
Okay, Mr. Fry, any questions?
How you doing today, Mr. Davis?
Pretty good.
Good. So do you have parenting time with your children ordered right now?
Yes, at Catholic Charities.
Okay. And you are declining to exercise that time?
Well, because I would, no offense, I'd rather FaceTime my kids because I was getting more out of that than anything to do with that place. But then they took the FaceTime away. And my daughter tried to call me the other day, and then they blocked her number so she can't. So.
But just to be clear, you could be having parenting time every week right now if you chose to have it?
For an hour.
Yes?
It's a loaded question.
It's a yes or no question.
But it's at a place that puts my kids in risk of either getting head lice or me getting my parenting time taken away. So it's a loaded question.
So if I'm understanding you right, you only want parenting time if it's where and how you want it?
No, anywhere but that place. It's that simple. And they're my kids.
When's the last time that you've actually had parenting time with your kids?
July.
You testified that the woman that you're currently living with, her kids have met your kids. When did that happen?
At my parenting time? It's at a park.
Okay. At a park in the past?
Yes, and they ran into each other, and we acted like we didn't know each other to see if they would get along, and they did. And Megan knew about it.
They just randomly ran into each other at the park during your parenting time?
Well, we wanted to see if they'd play together and get along before introducing them.
Okay, so you did it on purpose?
Yes, Megan knew about it.
Now, you have testified also earlier that you had moved and you expressed surprise that the worker knew about that because you said you never told her. Is that accurate?
I didn't tell her.
So you moved without telling the worker that you'd moved?
Yes, I told my lawyer.
When'd you move? When'd you move?
3 weeks
when
ago.
When did you move?
3 weeks ago.
So you've only been living in your current house for 3 weeks?
Yes.
How long have you been dating your girlfriend?
3 months.
Okay. So where were you living before you moved to Carrollton?
In Tecumseh.
So to be clear, you are the one that chose to move an hour plus away?
Yes.
Okay. And you don't have a driver's license, is that right?
Yes.
Even before you moved then, you still weren't exercising your parenting time?
Not. Yeah, I mean, I did, and then I moved.
Well, I'm just saying,
I tried to
you
prolong my
testified earlier
visit.
that you testified earlier that you weren't doing your visits because you couldn't get there, right?
Yeah, 2 weeks. My bad.
But you've only been living in your house for 2 weeks. Is that what you're saying?
No, I only missed 2 weeks while I was living there.
Okay. Now, is it fair that the primary reason that you're not doing your parenting time isn't distance or driving? It's just that you don't want to do your parenting time, in this location with this supervisor?
No, I got my proposed divorce agreement from my lawyer, so I assumed that all this would get sped up when we'd agree to 50-50. I just assumed everything was going to get sped up, and I would have got my kids back once they realized all this stuff was bullcrap.
You just pled guilty to a criminal offense involving a firearm, right?
Out of a misdemeanor that I admitted to doing from the very first day.
Okay. Well, you admitted to recklessly discharging a firearm.
Yeah,
I did. Pled guilty to that, right?
Yes, I did it. I didn't deny that.
Okay.
I've never once
And the
denied that.
kids,
My kids
the
were not
kids
around
were
for
around
that.
when you, the
They were
kids
not
were around
around.
when you engaged in that behavior, right?
No, they weren't. I was home alone.
Okay.
There's body cam footage of me being home alone, so I don't know what you're trying to argue here.
You were previously engaged with Adrian Counseling and Psychiatric, right?
Yes, and then my counselor told me if we were just going to shoot the shit, word for word, like she said, that's all we do. I don't need it.
So you stopped going?
She said I didn't need to. She was going to cut me back to 2 weeks. She's like, if you want to just come in here and we can shoot the shit, then we can do that. And I was like, well, I'm not going to pay out of pocket every time I come in here just to talk. Doesn't make any sense.
And in the court report, it indicates that on August 12th, the worker contacted Adrian Counseling and Psychiatric Clinic, and they stated that you were no longer engaging in your therapy services. Is that accurate?
Yeah, I don't go to counseling. I already said that.
So you stopped doing that?
Yes.
Okay.
That was already said before when my lawyer asked me that.
So would you agree that you have not been following your case service plan?
What I don't understand is why there's even a case service plan. If those charges were dismissed, what is the point of all of this?
Nothing further.
Thank you.
Any questions, Mr. Brooks?
No.
Okay, any redirect, Ms. Thomas?
I have none. No. Did Miss Underwood go?
Oh, right, yes. Ms. Underwood, did you have any questions?
I do, yes. Thank you, Your Honor.
Go ahead.
Mr. Davis, do you believe that your behavior has created any trauma for your children or your stepson?
No, I think the court has.
So you believe that just because you took a plea deal that the CPS case should just disappear?
Well, my ex-wife already under oath admitted that I have never physically abused our children when McFarland asked for that in court.
So I asked you a yes or no question.
They weren't home when I shot my gun off. They wouldn't have known about it if no one would have talked to them.
Okay, so my question again was, you believe that this case should just disappear because you took a plea deal?
No, but I believe you guys should maybe do more figuring out, investigating.
You signed a case service plan, correct?
I should have had my lawyer look at it first.
You were
And
ordered into services?
Isn't it all volunteer?
I'm asking the question, sir.
Well, it's a fair question. Isn't
You
it
were
all
ordered
volunteer?
into a case service plan, correct?
I don't know. I thought it said it was volunteer. I'm doing the best I can, but
When you were having your parenting time in Tecumseh, wasn't it because it was supervised by Orchards?
yes. Is that with Megan?
Again, I'm asking you the questions.
Then yes.
Okay. So Miss Davis didn't just decide on a whim to change where the parenting time was located. It was because your services with Orchards ended. Is that correct?
I didn't say it was Miss Davis that changed it.
Okay. So where Miss Davis is offering the parenting time is at her employer's office, correct?
What?
She's offering parenting time where her employer is located at the DHHS building. Is that correct? Or at Catholic Charities?
So she's employed there?
I'm asking you if she is offering your parenting time at Catholic Charities or through DHHS.
Shouldn't it be mutual?
Again, I'm asking you the question, sir. Can you just answer the questions that you're asked? Your Honor, I have no further questions. It's clear that this witness is refusing to answer questions.
I just don't want to say the wrong thing.
Okay, did you have any other questions for your client, Mr. Raines?
Well, I just, a comment. I don't think my client was refusing to answer any questions. I'm not sure if he understood the questions exactly. I think he's answered every question that's been asked of him of each attorney. There was one question that I didn't hear a response to. And if Ms. Underwood would like to pose it again, I would encourage my client to try to respond, but I don't think he's refused any questions.
Your Honor,
Okay,
I feel
so-
as though I asked 3 questions in a row that were responded to with a question. I'm not going to proceed with his attempts to.
Did you ask them correctly, though? Because you asked if my ex-wife worked there.
Okay, thank you everyone for your insights on that question and answer line. I appreciate them. But Ms. Underwood has declined, and I think by default, Mr. Raines has also declined to ask any additional questions. Last opportunity for the gentleman in the courtroom.
Nothing further.
No, I have nothing further.
All right, any additional witnesses today, Ms. Thomas?
Yeah, and I briefly just need to get Ms. Smith on the record, but I would ask everyone else if they need a humanitarian break. I understand how long this hearing has gone, and so I just check in,
No, it's
but
good
otherwise,
timing.
Ms. Smith.
I've got 2:49 here, so why don't we take a recess? You were about to call your next witness, Ms. Kristen Smith. Is that still where you'd like to go?
Yes, Your Honor, thank you. Hey, Ms. Smith. All right, briefly, because we've already had so much testimony, I just need to make sure you authored the court report that's before the court today, correct?
Yes,
And there are several attachments, and then you also provided separately from that packet an additional document related to the middle child and her therapy notes, correct?
correct.
And are there any updates or modifications that you're aware of that need to be made to your report or to the documents that you've submitted with it?
No.
Okay. As it relates to some of the testimony you've heard today, I just want to clarify a few points. Have you received any updated income verification from Mr. Davis during this last review period?
I don't believe during this reporting period. I've received one since the case has started. And that's the letter that Mr. Davis is referring to that his employer sent me.
Okay.
That was by text.
And then as it relates to parenting time, can you confirm the last time that Mr. Davis exercised parenting time?
I believe it was on June 3rd.
And would that have been with Megan Spears through Orchards?
Yes.
It was July.
Okay, Mr. Davis, the timeframe for your testimony has concluded. Please don't interrupt.
Thank you, Your Honor. All right. And let's see. As it relates to his testimony that the children got lice from, I don't know if it's clear whether it was the department or Catholic Charities. Was that ever addressed in this matter?
It was very early on. It was shortly after the removal, and they actually got head lice from the daycare. And then they came to the office and actually brought the lice to our office. And during that visit, I had asked Ms. Davis to put hats on the children, which she did.
Okay. And that would have been back in November?
Correct.
And generally speaking, both Mr. Anderson and Ms. Davis are fully compliant and or have satisfied all elements of their case service plan?
Yes.
And as for Mr. Davis, he has been very compliant with his case service plan, other than communicating with you, keeping you informed on some of those basics that are part of a standard case service plan. And then obviously lately the parenting time, but as other services, parenting education, the anger management, domestic violence classes, compliance with probation, the drug screens, all of that has been okay enough, correct?
Correct.
Okay. Some of the, I guess one of the main things that we've heard from Mr. Davis is his inability to work with you. And do you have any issues with Mr. Davis that you can't work with him?
No, I work with essentially all of my clients are difficult. Either they like me or they don't, but based on their progress, their engagement, their benefit, that's where my recommendations, come from. Mr. Davis has a difficult time engaging with anybody. FTMs, TDMs that are actually facilitated by a third party, he has been terminated from because he's been disrespectful, rude. Any essentially person of authority, Mr. Davis has a very difficult time engaging with.
You've included some screenshots of text messages between the two of you, and then also a thread of emails. Are there any updates to those communications?
No.
And so you made a valiant effort to continue to ensure that Mr. Davis could exercise parenting time. You made a valiant effort to engage with his attorney as he asked you to do so. And there's even an email from me in which I have never received an email response from either Mr. Rains or Mr. Davis. Have you?
No, I have not.
Okay. And at this time, do you believe that Mr. Davis has demonstrated benefit from any of the services that he's engaged in, despite having good recommendations from the service providers?
No, I don't.
And can you briefly elaborate why you have that opinion?
Throughout, since start to finish, Mr. Davis has not, he still doesn't take any accountability for his actions. He doesn't feel that he's traumatized his children. He said today, essentially, that, because he took a plea deal, essentially, this should all go away because it didn't happen. That's not the case. If Mr. Davis can he works in Carlton, lives in Carlton, but works in Tecumseh. He has no problem getting there for work. I don't understand the difference of driving to Adrian to see your kids. Mr. Davis has not engaged with me or anybody else from the agency to try and, reduce these barriers that he seems to have. But I don't think that Mr. Davis thinks that he has any issues. And I don't know how to service that.
Is there a reason that parenting time at this point in time is being recommended to be supervised at either the department or Catholic Charities?
So it was essentially, when the case started, recommended that his parenting time be only at DHS, given the reason for the case, his violence. They wanted security to be there. And then we moved it to our agency and made sure that we had additional staff in the office. And then when Ms. Spears took over and she was transporting the children for visits and helping out with that, then she was comfortable with it in the public place in the park. And those visits went well. And several weeks before that program ended, I had made attempts to get with Mr. Davis about setting up visits, knowing that that program was going to be ending. And still he refuses to. I offered that we could do visits at, a park in Adrian. I offered outdoors. Now that it was summer, we have several parents who bring strollers or wagons. We do chalk outside. We do scooters. I offered all of that. And essentially he just told me that I need to contact his attorney. So that's where we're at.
And do you believe, I'm going to actually strike that question. Frankly, I don't have many questions of you because the parents have essentially agreed that everything in the report is accurate. I guess the only point is that Mr. Davis has indicated Ms. Spears provided information in which she would not recommend supervised parenting time. Do you have that with you, or were you ever provided that?
I do not have that. Mr. Davis has sent me probably 50 to 100 screenshots of text messages that I have weaned through. Most of them is just arguments between him and Ms. Davis. So if it was in there, then it was missed. But no, I don't have anything from Ms. Spears stating that his visit should be unsupervised.
And that's not in her report to the best of your knowledge, is it?
I don't believe so. I'm also not sure, just in working with orchards, I'm not sure if they are even able to make a recommendation to the court of whether visits are supervised or unsupervised. I think that they just report on how the visits go in general.
And at any point in time during your work on this case, have you ever indicated to any of the parents involved that the court orders were simply voluntary?
No.
Thank you. I have no further questions of Ms. Smith. I would ask the court to accept the court packet. There might have been two submissions, a pretty lengthy one of like 62 pages, and then another cover sheet with a therapy report for the middle child.
Objections?
No objections.
No objection.
Thank you. They are received, including the additional report that came in August 18th. Questions for this witness, Mr. Rains?
Yes, ma'am, you were asking questions about your communication with Megan Spears. Have you, in fact, inquired of her as to whether she has recommended that there be unsupervised visits between Mr. Davis and his children?
No, I have not specifically asked for that.
Why?
I haven't been in contact with Ms. Spears since her reports. She sends me an email with the report. That's the extent of it.
You would agree that there's nothing in the case report that she authored that would indicate that supervision is indicated. Wouldn't you agree?
Can you repeat that? I guess
Sure.
I don't
You would
understand.
agree that there was nothing in the report that she authored that you've attached as part of the report for today. She didn't indicate anything that would indicate that supervision is required, did she?
No.
In fact, she has indicated that Mr. Davis had displayed bond and attachment with both of his children, showing them physical and emotional affection throughout each of their visits, correct?
Correct.
And this was progress that was made by Mr. Davis over the course of all of the visitations that he exercised, correct?
Yeah, I don't think that Mr. Davis ever was not necessarily bonded, or, I mean, the very first visit that I watched, the kids were excited to see him. That wasn't the issue. It's Mr. Davis's behavior that is the issue.
But it's not his behavior with his children, though, correct?
Not always, but yeah, we've had to end meetings because of his behavior when the children have been present. He's told the middle child that he wasn't her dad anymore.
Well, that wasn't within this last reporting period, was it?
No, that was the last reporting period.
Okay. Over this last reporting period, according to what Ms. Spears has observed, everything seems to have been appropriate. Would you agree?
Yes.
And those visits that were occurring with some progress have occurred in a community context, not at DHS or at the Catholic Charities Building, correct?
Correct.
And it was Mr. Davis who had requested of you, probably repeatedly, that he be able to have those in the community, including at a park in Tecumseh, correct?
Yes.
That would have been continuing what the status quo had been for his visits with his children, correct?
Correct. And I asked Mr. Davis, per his request, if he would like to expand his visits to twice a week. Those text messages, I believe, were also submitted, and he declined.
Well, you declined the opportunity to have the children in Tecumseh, correct?
Correct.
You have only insisted upon those being exercised at DHHS, right?
Or in Adrian. I offered parenting time of Parks and Adrian.
Okay. Is this a matter from the sake of DHHS of convenience, that simply there's not transportation that's available to take the children to an area where they had been exercising their parenting time with their father?
No, our agency services Lenawee, Hillsdale, Monroe. We visit in Detroit.
Okay, so DHHS has has been able to transport the children to Mr. Davis's preferred area where he had been exercising parenting time.
Ms. Spears has, the supportive visitation coach for the 16 weeks, offered that service. And then when I tried to contact Mr. Davis to set up a plan, he refused to engage with me and asked me that I contact you.
All right, but ma'am, just all I'm asking is DHHS capable of having the children continue with the community visits that would be in Tecumseh?
Yes.
And that's what Mr. Davis requested of you, correct?
Yes, and I asked, essentially, we're not going to accommodate him when he can't provide me with his income, his schedule, anything.
Okay.
He refuses to engage with me or provide anything to the agency. So
ma'am, you were willing to have the children transported at his request to Tecumseh so that those children could visit their father, but you didn't get income information from him? And that's what held it up? That's what stopped you?
No, it's his lack of involvement and engagement. He won't communicate with me, as I have continued to provide documentation of for the last 9 months.
Well, your interest is in facilitating a relationship between these young children and their father, correct?
Correct.
And those children have been excited about seeing their father, and the reports are that those visits have been positive, at least within this last reporting period, correct?
As far as Mrs. Spears has reported, yes.
Well, you haven't observed them interacting with their father, have you?
No, because Mr. Davis hasn't engaged in parenting time.
Well, Mr. Davis has requested of you that parenting time occur in Tecumseh to continue that. You've had the ability to.
Your Honor, I'm going to object to this line of questioning. If Mr. Raines wanted to counsel his client, he should have done so when I emailed him earlier this month and encouraged him to tell his client to comply with a court-ordered case service plan, in which that means that his client is to communicate with Ms. Smith. So I'm going to object to this line of questioning as to relevant. We have established that there's a line of communication that all Mr. Davis is continuously saying is talk to the lawyer. Ms. Smith attempted to do that.
Okay, any comments about the relevance in response there, Mr. Raines?
Yes, my client has clearly, according to the witness, expressed an interest in seeing his children and has communicated with her according to what the witness has indicated. And she has indicated that she would not present the children to Tecumseh. She's insisted upon, I believe it's Ormsby, and Adrian instead. So I'm asking her about what is really the impediment for him to be able to exercise his parenting time. And I believe I understand, at least in part, what that is. And that's the failure to present income information, apparently. I think this is all relevant to his communication, the communication of the witness with my client.
Does anyone else wish to make a comment on the objection?
Your Honor, I would say that Mr. Raines has mischaracterized the testimony of the witness and has become argumentative, so I think the objection should be granted on that basis.
Any comments, Mr. Brooks?
None that I think anybody would appreciate. No.
Ms. Underwood?
I believe it's accurate that Ms. Smith reached out to Mr. Raines per the request by Mr. Davis to further discuss parenting time. That attempt was not answered. And so again, I think it's been asked and answered and also reflected in the court report.
Yeah, I agree with Mr. Fry. He phrased it how I was going to respond, which is that these testimony speaks for itself. This line of questioning is argumentative at this point, and in fact, cumulative. The information has been presented, and I would ask you to move on to your next question, Mr. Raines.
Thank you. With respect to the income information, you do know who the employer has been for Mr. Davis, correct?
I believe it's the same employer, yes.
Have you requested any income update from the employer?
No, it's Mr. Davis's responsibility to provide me with monthly income verification for his case service plan.
What was the daycare facility that was investigated and it was determined that lice was at that facility?
I'm not sure it was necessarily investigated. The children started attending the daycare upon their removal, and it was noted that I believe one of the children there had lice, and then the two youngest in this case also got it.
Okay, just what was that facility or that daycare location?
It's a daycare in Adrian, or in Tecumseh. I can't think of the name of it right now.
Okay. Did you direct that the children not be able to have any video contact with their father?
Not necessarily. His parenting time is supervised per the court order and at the discretion of the children's therapist. And any additional parenting time, essentially by FaceTime or Zoom, is just that extra. If the children, that's a perk of the kids being cared for by a relative, is that they do have that opportunity if they don't use it. If the children were placed in an unrelated licensed foster home, that wouldn't be available to them. Mr. Davis abused that several times by calling the grandmother a fucking cunt.
You think that happened on more than one occasion?
Yes.
It sounds like you're not necessarily disputing what Mr. Davis has indicated to you, that Ms. Spears, there's text messages from Ms. Spears to him that supervised parenting time is unnecessary, because you just haven't looked for it or haven't found those messages?
Correct. I'm not disputing it. I just have not seen them. He informed me that he was going to be submitting, he doesn't trust me, so he said he was going to submit everything to his attorney, so.
All right, ma'am, those are all the questions I have for you. Thank you.
Thank you. Mr. Fry, any questions?
How you doing today, Ms. Davis? Ms. Smith, sorry. It's been a long hearing.
I feel that.
So sorry about that, Ms. Smith. Has Brianna Davis successfully completed her case service plan, in your opinion?
Yes, I believe so.
She's done everything that you've asked of her?
Yes, she has.
Okay. Now, as far as Mr. Davis, when is the last time that he exercised any parenting time?
I believe it was
Objections are asked and answered.
Oh, Mr. Raines, you know that attorneys get to ask the same questions even if they didn't ask them the first time?
Okay.
So this reporting period started May 29th, I believe, right?
Yes.
So he exercised, what, one visit of parenting time during this whole reporting period?
Sounds accurate.
Okay. Now, how is the process for the parenting time? Are the kids brought somewhere? Does he have to give notice on the day of or ahead of time?
He needs to confirm 2 hours prior to the visit.
So the kids don't know whether they're gonna see their dad, until 2 hours before the visit starts?
Yes, we
Yes.
Is that traumatic for the kids every week? Potentially wondering if they're gonna see their dad and then him never showing up?
I'm going to object. It's speculative at this point. I don't know if the witness has qualifications to offer, whether it's traumatizing for these particular children or any for that matter.
Well, did you want to lay some foundation on whether or not she can answer that, Mr.?
I can just rephrase. a little bit here. So, do you have any interaction with the children?
Yes, I do.
Okay. And do you have any insight on, how it would affect them when their father continually doesn't show up for the visits with them?
I'm going to object and for more foundation. I mean, just the fact that she's had contact with them, I don't know if that's one telephone call with them 3 months ago. I don't know what that means.
The question was just how she has observed it affecting the children. There's no foundation needed to answer that question.
Absolutely.
Would anyone else like to weigh in on this objection?
I wish everybody'd shut up and just move on with what matters, which is a long way from where we've been, which is why I held my voice earlier on that objection, where I thought the exact same thing.
Okay.
We're just arguing for the fun of it.
Ms. Thomas, did you have an opinion on the objection?
I guess to me, the rules of evidence don't apply. It sounds like it's more of a weight of the evidence situation here. And I believe the court has the discretion and can make that determination in its findings.
Ms. Underwood?
I have no position.
Thank you. The witness can speak to personal observations, so the objection is overruled. Did you need to have the question repeated?
Yeah, repeat the question.
So, have you observed any effect, the father, not continuing to not appear for his parenting time, having any effects on the children in this case?
I haven't, because of their ages, and also their awareness of dates and times and when they should be seeing him. That's not something that I directly ask them. I will say that during my monthly home visits, when I ask, how things are going at home and in school and with mom, they don't bring up dad. I think that in therapy, the middle child, might ask more about it, but for me, it appears to be out of sight, out of mind. They don't know Thursdays come and go. I don't think that they've had that consistency to miss it.
Okay, thank you. I have nothing further.
Questions, Mr. Brooks?
One, I promise. And do you have any objection to the court releasing jurisdiction over the Anderson child?
No.
Thank you.
Ms. Underwood, any questions?
No, Your Honor.
Redirect, Ms. Thomas?
No, Your Honor.
Mr. Raines, do you have any recross or any other questions?
Nothing further, Your Honor. Thank you.
Thank you for your testimony. You may return to your seat. Any other witnesses today, Ms. Thomas?
No, Your Honor.
All right. Witness testimony today, Mr. Raines?
None, Your Honor.
Mr. Fry?
No, Your Honor.
Mr. Brooks?
No.
Ms. Underwood?
No, Your Honor. Thank you.
Very well. Comments in closing, beginning with Ms. Thomas, please.
Your Honor, I'm going to keep this very short. I think that the record at this time speaks for itself. We are asking again to just release the oldest child with Mr. Anderson from the court jurisdiction. And if the court's not inclined to do so, I do appreciate the offer earlier of a mediation. I also think that the parents are on the same page. And it's just a matter of getting a stipulated or consent order into the custody file. And if we keep it open, I know that we can do a 7-day notice as well. So I'll just leave that to the court's discretion. As it relates to mom, we are asking that the agency have the discretion for reunification with FRP services in place. And that will trigger the mandatory requirement that the agency reach out to FRP within 30 days of the order to get that in place for mom and the 2 youngest children. As it relates to parenting time with Mr. Davis, I think that this court is really well aware of the facts and circumstances that brought us here today. I mean, it had the children removed. And based on his testimony, it's very clear that he is not benefiting from any of the services. It sounds like he really just is checking off a little box saying that he did things. And I really think that it's more at the threat of criminal prosecution rather than actually wanting to benefit for his children. We continue to see that in all the assessments and reports that we've had as it relates to the children. There's really no denying that these children have this trauma. I was looking back at the original stamped petition that was filed and the disclosures that the children have made. Mr. Davis had pled no contest, and so this court can accept those allegations as true. We have the psychological evaluation, while not as thorough as we're used to, also indicating that he is prone to some of these personality characteristics that would make him feel targeted. And I think we're seeing that. I think that we are also seeing anyone working with the department, the court kind of collectively being called into his brain as being the problem rather than himself and taking accountability for his own actions and what caused his children to come into care. We are at reasonable efforts, and frankly, all the case law supports that. Reasonable efforts is letting the parents know where they can find services and sending them on their way. Fortunately for us, we have a very strong county and a very strong community here, and we have strong expectations from this court. And our workers on a very regular basis offer parents active efforts, and I believe that we are here. I don't think that it's unreasonable to want parenting time, the supervisors of parenting time, to want that to be close to their home base, especially considering the conduct and capacity of this individual who has a history of violence and is dangerous. That's very well supported in all the documents that we've had, and he has done nothing to demonstrate a willingness to engage appropriately with Ms. Smith or someone else from the department. And so I really just think that if you're going to continue to offer supervised parenting time to this parent, we would ask the court that it remain supervised. And I guess note to the parent that your orders are not voluntary, they are court orders. So thank you with that. And with that, we're just asking for, I guess, a 90-day review unless a custody order is cut from circuit court before then. Thank you.
Comments, Mr. Raines?
Judge, just with respect to Mr. Davis, I am not sure what the basis is for the updated case report under provision C about likely harm if the children were returned to Zachary Davis. It mentions possible exposure to significant domestic violence, possible physical, emotional abuse, and exposure to parental alcohol use. My client hasn't used alcohol in over a year. There's been an alcohol tether that he's been strapped to. You've heard that there have been no violation of bond conditions during the entire period of time that he was using that until he was released from that last Friday, pursuant to an agreement from the prosecuting attorney's office. Your Honor has heard a great deal about the progress that Mr. Davis has made. There has been a dismissal of the felony charges that were against him. He has a reckless discharge of a firearm in which the children were not involved and were not around. There probably have been some stories that have been told about Mr. Davis, and those have been shared with the children, and maybe that is something that could have caused the children some discomfort, but not the behavior that he is engaged in front of the children. That does not appear to be present from any of the reports. For it to be argued that all of the reports suggest that there's a problem, including domestic violence, I would just look at Exhibit N in the discharge summary. His attitude has been excellent. His attendance has been excellent. His participation has been excellent. He's completed 12-step programs, AA attendance. He's gone through co-parenting. He's been honest and open regards to his addictive behaviors that he's had in the past. The report is, I believe that Ms. Smith has even indicated from Ms. Spears is that the parenting time that he's had with his children has gone well. The only thing that has been he's been criticized for is a comment that he has made where he has used foul and inappropriate language, not to the children or not around the children. So has he referred to some people who are in authority positions in a negative way? Yes. But how is that negatively impacting upon his parenting? It's not. In fact, we've heard that the community parenting that he was doing in Tecumseh was going very well. Unfortunately, the DHHS has been unwilling to accommodate him. He repeatedly requested in his communication with them that he be able to continue to do it there, and notwithstanding the ability, according to Ms. Smith, to facilitate that type of request, the answer was no. And so Mr. Smith has, as a consequence, not been able to have parenting time. He would indicate it's only been since the beginning of July, not before that. He has a good relationship with his children. The children have been excited to see him in the past. That's been clear in the reports that we have. I think the parenting time clearly should continue for Mr. Smith, and I would like that to occur in Tecumseh where he's better able to do it. It's not as if he refuses to have his parenting time. He's been requesting it, as is clear. He does have a problem with his license. He is making progress across the board, according to a lot of the reports that you have before you, and based on the update that I shared with you, Judge, about what's happened with his criminal case too, where it appears as if he's looking at a period of probation and he would continue to curb his use of alcohol. There is not a threat of domestic violence. He's completed the program. There may have been when Ms. Davis was with him previously, but there hasn't been any reports, any problems of that over the course of the past year. I think Mr. Davis has made considerable strides, and that is documented through the reports and the evidence that you have before you today. And I think his parenting time should continue, and we ask that it be preferably on an unsupervised basis, and that be within the Tecumseh area, he'd be allowed to exercise that. But I defer to you, Judge, as to what that would be as what's best for these children who clearly have a relationship with their father who's gone through the parenting classes and many of the requirements that have been requested of this court. Thank you, Judge.
Mr. Frank?
Yes, Your Honor. So my client, Ms. Davis, has completed her case service plan. She's done everything that's been asked of her of the court. She has a good bond with the children. This past reporting period, she's been doing extended overnights with the children up to 4 days consecutively. We'd asked that the court adopt the recommendation of returning the two youngest children into her care. Further, the testimony has established that she has a good relationship with Mr. Anderson, and they co-parent the oldest child well together. So if the court felt inclined to discharge, the oldest child, that seems like it would be appropriate at this time. But she has done what she needs to do to have these youngest children returned to her. As far as Mr. Davis's parenting time with the youngest children, he has only exercised one visit this entire reporting period, which has been the last few months. Right now it's apparently weekly, and it's unknown whether he's going to actually exercise it until the day of. So everyone and the children, have to plan around that, only for him to have not exercised it at all during this full time. So, that clearly, has to be hard on the children and traumatic for the children to have to go through this on a weekly basis. Everyone has their own priorities. Clearly, Mr. Davis's highest priorities are not his children, and that's been shown through his actions. So we would ask that his parenting time either be suspended at this time until he can make some more progress, or at least his visits be changed to every other week, so the children don't have to go through this process every week only to have their dad not show up for them. We've heard from the testimony from Ms. Smith that she has not seen any changes in him despite the services that he's undergone, and has not shown progress. So we think that would be appropriate as far as his parenting time, but the children should be returned to my client, Your Honor. Thank you.
Comments, Mr. Brooks?
I take no position with regard to the Davis children. I represent someone else entirely, and this doesn't directly affect his interests. With respect to the Anderson child, I've heard the evidence today, and I think the court is well advised by me to dismiss, to release your jurisdiction of this child and leave the parents to their own devices.
Thank you. Ms. Underwood.
Your Honor, it's become clear to me, not only during this hearing, but during the majority of these hearings, that Mr. Davis continues to take no responsibility or accountability, and frankly, refuses to even attempt to understand the circumstances that brought these children under the jurisdiction. The fact that he doesn't believe that these children have been traumatized is just mind-boggling to me, for lack of a better word. The children's therapist has previously testified extensively, even providing photographs or photos and pictures that one child has drawn, showing Mr. Davis with a gun in his hand and pointing it at the child's mother. These are real things that these children have endured, and Mr. Davis fails to understand the potential harm that he has created for not only his children but his stepson. My job is to determine what's in the best interest of these kids, and frankly, I feel like Mr. Davis is becoming less cooperative, less understanding, and thinks that because he took a plea deal means that, everything is just going to magically disappear, when in reality, it doesn't take away what happened. There's just a criminal resolution to his case. The trauma still happened. The event still happened. The outcomes and the fallout has been very real on these children. If parenting time is going so well with Ms. Spears, then Mr. Davis should have called her as a witness. He has every opportunity to call witnesses in his favor, and he's not done that today. He's choosing not to engage in services. I don't think Ms. Smith needs to jump through hoops to get Mr. Davis to see his children. In fact, when she attempted to set up additional visits, he called her irrelevant and said to talk to the lawyer. And she further offered twice weekly supervised visits, and he's failed to respond. So not only has she offered visitation moving forward, she offered it twice weekly when he was only get it once per week. And again, attempts were made to contact his attorney, and they were not responded to. So again, I don't know what more Ms. Davis could have done. Ms. Smith could have done. I also believe that it's important to note that Ms. Smith has originally, in this case, Ms. Smith and Ms. Davis had issues, and Ms. Smith was hard on Ms. Davis, but rightfully so. I think that she was consistent in protecting the children and ensuring that these kids were safe. And Ms. Davis started working her case service plan and benefiting from services. Mr. Anderson has done the same. So it's not Ms. Smith here. 2 of the 3 parents have made significant progress here, and there's one that's not. And that's unfortunate. I would also ask the court As we can see on video, Mr. Davis has been repeatedly inappropriate throughout this entire hearing, making comments while he's on mute, speaking to somebody in the background. I would ask that all further hearings he be required to attend in person. This is a court proceeding and we should behave as such. I would ask that the court, if supervised visits were to occur or if visits were to continue, I would ask that they be supervised at the start and then allow them to be expanded if Mr. Davis can show that he can be appropriate. But at this time, he has not shown me or anybody else the fact that he can behave in a way that would allow for unsupervised visits. I would ask that the court release jurisdiction of the minor child LA with the understanding that either mediation will occur or a stipulated custody order will be put into place within, I would say, maybe 28 or 30 days, something like that, to ensure that there is a updated custody order and parenting time order in the file. I would also concur with the department that that the children be reunified with their mother, with FRP services being put into place, and ask for a standard review on all parties remaining in the case. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing and permanency planning hearing. Reunification continues to be an appropriate goal for all three children. Tyler Anderson has had his son return to his care and he's doing well there. And the other two children, the court is ordering them to be returned to the care of their mother effective today. So I'm glad to see that reunification has occurred with these two parents, and that will maintain moving forward. I'm not inclined to release the oldest child from jurisdiction today. I have included language in the order that reflects that the parents are offered the standard mediation rate. And by that, I mean Tyler Anderson and Brianna Davis. It's not a high rate because it's court, right? So we know for a fact that SEDRS will accept that. I think Mr. Shadler has accepted it in the past. I don't know if he's still doing mediations. You're welcome to find a mediator of your own choosing, if you like, that would be willing to accept that rate, but the court will support you in that, at least to that extent, to mediate potential resolution to the custody, parenting time, and child support modifications that take into account these proceedings in the current circumstances of the child. I have noted, just for your reference in the order, that the child is obviously placed with Mr. Anderson, and that is contrary to the 2022 order granting mother sole physical and sole legal custody. So with that guidance, I wish you the best of luck in resolving those outstanding issues. And I would invite Ms. Thomas and the attorneys to submit something moving forward that does document if you have an agreement, and that's put into place so that you may not have to appear for the next hearing. So good luck as you move into the next phase of things for your family to that extent. As it relates to the other two children, Ms. Davis is going to remain under the jurisdiction of the court. I'm glad to see that you've made significant progress on your services. I too was very, I would say, as I think as Ms. Nero put it, hard on Ms. Davis in making sure that she demonstrated that her priority is her children. And I see that she's been able to do that and accomplish that. And so I'm glad to see that she will have the opportunity then to provide as the primary parent for her children moving forward. That being said, I know we do have a hearing coming up Tuesday, September 16th on the pretrial on that divorce case. And I would be inclined to still go ahead and set a trial date on that as well. And so that we can, and if the two of you want to agree to stay on for a minute afterwards, we can look at literally just opening up that pretrial today, if you wish. Or setting some dates if you want to see if you can get a hold of your attorney on that, Ms. Davis, and give you a few minutes to do that so that we can get perhaps even a trial date on the books so that the two of you can also have some resolution on the outstanding custody, parenting time, and child support issues. Because at this point, that will appear, assuming that Ms. Davis continues to do as swimmingly as she has, that will be likely what you'll hear from me at the next review period as well. If those issues have not been resolved, that those need to be resolved. And in this case, I think it's especially important as it relates to the younger two children, given the developments that happened on the record today. So this leads me to speaking to the request of Mr. Davis on parenting time. I will continue to grant him the opportunity for supervised parenting time according to what he's entitled to under the manual, with the exception that that's going to be at the discretion of the both children's therapists. And that's because I just want to revisit this for Mr. Davis for a moment, and I won't take too much of your time. But the petition that was filed, it was a supplemental petition that ended up being the subject of the plea in this case. And that was submitted November 21st, 2024. It indicated a number of really serious things that did happen in front of the children, including Mr. Davis threatening Ms. Davis that he was going to cause harm to her stepfather. And let's see, where was the other one that was really? Yes, while she was loading, this is from paragraph 8H, she reported that while she was loading the children into the car, both back van doors were open, with the mother standing on the driver's side and the father on the passenger side. The father pointed a pistol directly at her through the van and made a statement to the effect that he should just kill her and that would solve all the problems. Brianna, the next paragraph reflects, Brianna stated she thought Zach was going to shoot her, and in fear, she ran to the back of the van out of the line of fire. When Zach did not shoot her, she got in the van and fled with the children. The couple continued to argue over the phone leading up to the gunshot, which is, I would assume, the basis for the plea that was eventually taken, wherein the children were no longer part of that interaction. God, frankly. So there were some very serious issues that happened that day. There was a BAC of 0.12 that Mr. Davis blew. He was on probation at the time. He was taken into custody. There was also a number of hearings that took place where we heard from, well, at least one from Ms. Millenbach, where we heard about the children talking about how they were trying to process the trauma of what they had seen. It had a really real effect on these kids. Obviously that incident was very serious, but it was also demonstrative of a pattern in the home that was extraordinarily harmful to the children and resulted in many diagnoses for the children that they're currently still working on with Ms. Millenbach on a weekly basis. On December 9th, it looks like, Zach Davis took a no contest plea to that petition. And I explained to him at that time that although he did not have to indicate directly that he was taking responsibility for the allegations of the petition, that in fact the court would treat the allegations of the petition as though they were accurate and order services for him and his family to the extent that we could try to essentially rehabilitate him so that he could be a safe person for his family, for himself, and especially for his children. And that was ordered. He was ordered into services. They were certainly to address domestic violence and those dynamics in the house, his alcohol use, many of the things that he's had to address through other courts as a result of his criminal proceeding. But to simply deny today that any of that occurred as a result of the plea agreement that was entered is really quite extraordinary. I appreciate his frankness. It's very clear that he is not willing to take any responsibility for the dynamics that he brought into the situation with his children, that he's not willing to acknowledge their trauma as a result of that, or to work with the service providers that are in place in order to try to help his children overcome the damage that's been done as a result of those dynamics. So for all those reasons, the parenting time will certainly remain supervised. It will be at the discretion of, frankly, Ms. Millenbach. I know she's seeing at least one of the children, but it would be at the discretion of a therapist, given today's disclosures and events. I'm not going to require that he appear in person. If he wants to conduct himself in a way that is disrespectful to the courts, we will continue to be muted or asked to maintain appropriate behavior. But again, I think we're getting a very honest picture here of how Mr. Davis feels about himself and about his children and these proceedings. So to an extent, there is some value to that. I have some time available for our next review and permanency planning hearing on November 17th at 10:30 in the morning. That's only an hour and a half, given that the hope is that the custody issues in both cases could either be completely resolved or would be on their way to being resolved in the future.
11/17,
10:30.
10:30.
I'm available.
Mr. Raines, are you available for an hour and a half on that day?
Yes, I am, Your Honor.
Okay. All right. Mr. Fry will be on vacation, so the odds are low he'll be rejoining us.
I think I'll let Ms. Dumont step back in, Your Honor.
All right, very well. All right, the children will remain then, as the court has previously indicated, the oldest with his father and the youngest two with mom. Under the terms and provisions that I've indicated here, there's clearly still a significant risk of harm associated with Mr. Anderson's parenting time and custody. So I've already spoken to that at length. Those will be the orders moving forward, unless there's